Hi guys, how is everybody? It is day 165 of the YSL trial. No jury. They're still going to be working on jury charges and the verdict form itself. So that's the form where we'll check yes, no if we think guilty, not guilty. Interesting questions with there because the jury needs to understand how to check off everything on that form the right way. So not a small task. You think it might seem simple. It's not. So it's going to be a day of attorneying, lawyering. Good to see everybody. Hey to Nana Banana. Mackenzie says we all deserve a second chance. Agreed. Travis James, I think the jury checked out months ago. Yeah. Gnarly Marley says I feel productive that I'm here before it starts. Hey, you get that extra hour today, right? Morning to SteffJK. Hey to Cash Money Cass. Hey to Fatima. First thing I see Fatima saying is saying hi to somebody else. Love that. And I don't see Biff, so I think this is StreamYard doesn't always pull in all of the chats that roll in before the stream gets started, so missing some here. Hey to Sean. Hey to Life is Armani. Hey to Kerfuffle, one of my favorite names on here. Hey, Miss Jazzy. So we've got, I don't know, this is like the final countdown. It's like the final countdown. If you missed yesterday, you probably heard that Judge Whitaker did grant a directed verdict acquittal on 3 charges. Loved seeing that. She did throw the state a bone by not dismissing another 3 that she gave a partial reduction. A lot of that, and again, I highly recommend, you guys know Jim R in the chat, Happily Angry Lawyer on Twitter, X. State changed around how they charge certain things. Misconstrued the language. The theory being, and Doug called it out in court, that it could affect plea bargaining, right? If you charge a statute that not only carries a different floor on minimum sentencing, but also requires consecutive sentencing. You can't serve both sentences with something else at the same time. It's got to go after the other. It's got to be consecutive. That's a big impact on potential plea deals. So, seems like the state was up to some funny business. Whitaker kind of called it out, but then said, all right, when you charge the jury with it, we'll just give them a lesser charge, which I don't really love that. I think if they were being slick with it, if they had the indictment wrong, I don't think that that's okay, but what else is new in this court, in this trial? So, we also had several things that I thought were interesting about yesterday. I misstated, I said that John Floyd was with the DA's office. He is a special attorney that's like contracted with them. So he's not actually like a prosecuting attorney. He's not going to come and handle a case. With that being said, he's supposed to be a RICO expert, yet I think there were a few times where Judge Whitaker, who never done a RICO case before, seems like she really tried to read up on bookworm it. Like her personality to me seems like a bookworm. And there were a few things where she said, well, what about this? She says, well, what about this? And he goes, so that's our RICO expert that that's what we got from him. Lots of unopened, unanswered, and still open questions about this RICO statute here. Interesting concessions, I think. Maybe concessions isn't the right word. Going through jury instructions, and everyone did seem tired in that courtroom yesterday. Some of the things I think that they did were pretty good for the defense. They took out a whole clause that defined malice murder. And my explanation of why I think taking that definition out, it's still in the charge as they read the charge. Murder with malice aforethought. But by removing the clause that defines malice with a legal definition is different than the way I would use malice. If you walk by me and you purposely go like this to shoulder bump me, that's malicious, right? That's how I use the word malicious in everyday language. It's bad. It's not good, and you're doing it intentionally. It wasn't an accident. But the legal definition includes something happening that was unprovoked, right? I might say that someone's shoulder checking me. I didn't do that. That's unprovoked if you make me get into the details. But if you put the word unprovoked in my head, I'm reading the jury instructions, and you're asking me to think about the Shamel Drinks murder, I'm going to go, well, yeah, that was unprovoked, no matter who did it. And sure, I should go through the motions to say, well, was it unprovoked and this defendant did it? Right, I should be doing that. But psychologically, I'd want to remove, as the defense, I'd want to remove any opportunity for me to check a yes box, right? I don't even want them checking the yes, it was unprovoked. I don't want them having the opportunity to think about that. So I thought that was really interesting and a big win for the defense. They removed that clause. Just a lot of stuff. A lot of stuff yesterday. Yes, and it is Diamante Kendrick's birthday. Let's see if Doug says it in court. Let's see if Doug says it. So happy birthday here to Yak. Do we have other birthdays in the building? I feel like I haven't seen anyone in the chat say it was their birthday for a few days, so I don't know. 9 months ago, did people just go protest? Let's see. Good morning to Hell-Raising Angel. Hey to NJB. Yeah. Kathy says, love that a body said, a person loses attention after 15 minutes, but they went on for hours about nothing. Oh, yeah, and that part too. So in Georgia, there's a recommended statutory limit on closing argument time. 2 hours per party is a suggestion. I would imagine, and there's an additional clause that a party may move to request the court for additional time, and the court shall, and it's not a complete shall, right? You always hear me distinguish between the words, shall grant additional time as they deem necessary and fair. So there's a shall with a qualifier. So, for example, if the judge were to say, granting you extra time wouldn't be fair or reasonable, I shall grant you 0 time. So there is a shall in the language, but it's not like a binding must give more time type of shall, right? I would imagine that the state said, look, there's 2 defendants, right? And we have all these charges, so we should get more time. But what's interesting is it's not like Judge Whitaker just said, okay, well, they have 2 hours each, that's 4 hours, so we'll give you 4 hours, we'll bump it up. For whatever reason, the state has 5.5 hours with their closing. So that's going to be a time, you guys. That's going to be a time. and there was scheduling. And the state about lost their mind collectively when Whitaker said she wanted to let the jury start debating right before Thanksgiving, and she held firm with that. There's a little bit less time. She tried to give them Tuesday and Wednesday to deliberate. Not before closing. I don't know why I said that. Before Thanksgiving. She tried to give them originally Tuesday and Wednesday of deliberations. Now, what's the problem with that, right? If you're the state. What would you want to the you already know about juror number 56. Hilton launched up out of her chair. She was like, Your Honor, no. They did not want that. But it ended up being they're going to give Wednesday to deliberate, which I don't know. I know a whole day seems like a lot, but there are a lot of things that the jury's going to have to read through. So unless they go in there and they're all really pissed off at the state, I don't think, even if they are to come back with a full not guilty verdict, I think there's a smaller chance that they'll do that on Wednesday. I still think there's a chance because they could be pissed at the state. The charges are whittled down a little bit. I think Whitaker is making the jury instructions more concise, so if they sit there and read through the jury instructions again, it won't take them as long. I don't know. I think it's good for the defense, though. Definitely think it's good for the defense. So, yeah, and who is doing the closing arguments? I don't know, and I hope they're not allowed to tag team. There's been an unusually large amount of tag teaming. Letting one attorney from the state's table say something. It's like whack-a-mole. I try to argue to the judge and then, hold on, let me assist because you're fumbling over here. And you might see that once in a while, but it's not something you see happen every 2 arguments. So I don't know if that would be allowed at all in closing arguments, but I feel like if this is the trial to try it, they're going to try it. I have seen in other cases where maybe, it's going to go state, defense, state, right? And it'll be the bulk of their closing argument probably for the first half. The defense is responding to that. And the reason it's that order is because the state bears the burden of proof. So in closing, they're opening up with their closing argument of what they've put forth. Defense, they have the right to respond, right? And rebut what the state's saying about their client. And then the state gets to wrap it up. Wondering how they'll split their time, but who knows? There is a very good chance in my mind that even with 5.5 hours, the state will still run out of time. Oh, man. Yeah, crazy, crazy, crazy. SJS says, I would vote not guilty the moment I went back in the courtroom. I'm spiteful. Yep, I think it would be one of these, right? We've got a few people that would do this. They go right in and right out. And that's the state's fault. That's the state's fault. Let's see. Yeah, I mean, this is smart. Big Pork Chop says, I really think the state does not want to put Love in front of the jury again. She's a huge liability. This is smart. This is smart. I don't say this often. Embrace it, you guys. This would be a smart move for the state. Don't put Love up there, especially for 5.5 hours. Oh my gosh. Morning here to John and Brenda. Guys, so Talk to Me podcast, this is a kind suggestion. However, I'm not going to stream snipe. So if you guys would prefer to watch the protest stream, I will link to it, but I'm not going to share it over to the screen here. So definitely worth listening to that directly through Empress Fox's stream rather than stream sniping. So there's that link in the chat there. I think there might be something on X also. I don't know if they're streaming over there. Let me see. And also, if you missed it yesterday, there's a status hearing the Tuesday after Thanksgiving weekend for the severed co-defendants. So I think Whitaker plans on this being done. And you could kind of see that play out yesterday when she was holding firm on scheduling for this week and next week. She wants this done. And I think she's optimistic that the jury is not going to take that long to deliberate. I don't know why I keep mincing words. Okay, yes, there is also one on X. So this is... All right, so there you go. So, Shell, I'll be covering it, but I'm not quite sure if they'll put a camera feed in for a status hearing. On one hand, status hearings are sometimes really uneventful. On the other hand, it's Whitaker, and it's been so long that these defendants have been waiting that I do feel like there will be some action at this status hearing. So it's a toss-up. I think there's a good chance that it will be streamed, so we can watch it. If it's not streamed, we'd have to wait for anything that came out of it and then just do like a video recap on it. So D Holly here, thanks for the 5, says happy birthday, Yak, with the green amphibious emoji and the green heart. Always a good time here. And And hopefully they let him sleep. Guys, so if you missed yesterday, but you've heard Doug Weinstein 2 previous times recently say, hey, look, these deputies they keep, can you ask the sheriff's office to stop waking my client up? It's interfering with his ability to participate in his defense, right? Can't do a good job working to put your case forth if you get no sleep day after day. Well, Doug Weinstein says that they woke him up at 2 a.m. yesterday. Like, what is the justifiable reason for that? How could transport be the reason for that? Like 2 a.m. and the day before your birthday? I don't know. I think people move with some type of spite. That's the answer I've got in my head. So just ugly. So hopefully, like, isn't that crappy? Like saying, like, hope for someone's birthday they got to sleep later than 2 a.m. I don't know exactly how long Love's opening argument was. Let's see. Let me look at YouTube. I think it was 22 minutes before a mistrial because, okay, look at this, you guys. I'm like, oh, here's Love's, and then it says part one, and it's only 22 minutes long. So I think they did a part one right up to the point where they had to get the jury out there to make this argument for a mistrial right in the middle of opening statements. Um, let's see if we can find a whole segment or just the whole day. All right, trial stream day one. So looks like, when does Love start? Bunch of instructions. Okay, so Love starts like here. So 1:35. Wait, I don't know if they're arguing or she's done with opening statements. God, I had so many arguments on day one. Yeah, so then she goes again. So I'm not going to do the math on this because I'm not going to chop out. They had 2 different motions for mistrial here. Well, besides the first, and then Max gets up around, it looks like it ends about here. So, like, with the, like, just under, like, 4.5 hours, maybe, if we don't count this long break here and the beginning part. Oh, gosh. And no, we're not watching that again. We are not gonna, I do not feel like hearing Love talk about. I don't feel like watching that. Yeah, Red Bunny, I think this is it too. Like, she's either working on closing or working on the next YSL trial. I don't think she's gone. I just think they've got her out of the courtroom here. So, uh, heck yeah. So I was actually watching Cuff Boys yesterday because it was his recap on the messy day, right? So I was like, oh boy, I gotta watch it, right? And I was on my computer, wanted to go to my kitchen to cook, so I switched device, and Jennifer Devine was like, you got a shout out from Cuff Boys. So that was really cool. All the love here for Cuff Boys. Cuff Boys used to keep me up to date on the trial. There was a week that I missed. And I was like, how am I ever going to catch up with this? It was like week 40 or day 40-ish that week. And I was like trying to like walk. I had time to go to the gym and get exercise back in the day. And I was watching, I'm like, there's no way I'm going to catch up in the next 2 days with 9 hours, 7 to 9 hour days, 5 days. So I was like, oh my God, Cuff Boys got me through it. So love, love, love Cuff Boys. Um, and we've got to get, and I'll tell Doug too when I talk to Doug, um, Because I told Doug, I'm like, when this trial's over, you got to come up and tell us. I have some questions for Doug that I've been waiting on. But we're going to get Doug to follow Cuff Boys on Twitter. So that's going to be a good time. YouTube watcher says, bunch of rookies from the judge. Yep. Yeah. I don't know DT, but you're calling her DA judge or the judge? I don't know. Yesterday was definitely interesting. I don't think anyone really feels confident in the delineation of this conspiracy to violate RICO concept. I don't think we got there. So, and I'm saying in the courtroom too, not just us here. Like, we're here on the outside, like, oh my gosh, what? But I don't really think they got that much further towards clarity in this courtroom either. And it really sucks to take a statute and force the new frontier of how you're going to figure this statute out, trial and error it with people's lives. So that's a time. That is a time. I don't know why court hasn't started yet. I don't know. Sometimes it's just like that though, right? You think you have extra time, right? You get to start a little later, so you think you have extra time, and then suddenly like everything goes wrong when you had extra time. So who knows? Is there an update maybe? Okay, and just random here, but Joseph Papp says 5 hours of closing arguments. I kept seeing 5.5, so let's just be optimistic here. Let's please go with 5. Save us that extra half hour. So there we go. But I don't see an update on like, hey, this is why we're delayed right now. Big thank you to Norma Jean. Good morning. A body was messy for that yesterday. Messy for the scheduling, or do you mean messy for the day before? It seems like I think he just seems kind of like a messy person. So like I guess oh well. He just seems like a messy person. Like he launched out of that seat to say, uh, she's married to Shannon Jackson. Like, oh my gosh. Let's see. Touche says two moments I'm still stuck on. Viverito standing by her 24 million lie. Yeah, that was ugly. That was ugly. And she really tried to represent it like she didn't just say on the stand. It's another instance where on the stand she represented it as he had the capability to put a bounty on someone's head. Because the way Shart was asking the questions, he led into it with her putting in the quote of the Lucci, like, if I didn't like what how you treated your kids and your mom, you would have been dead or whatever. He asked the questions, and she stated in the witness stand, sworn in as a witness, that she thought the two were related because it meant he had the capability of putting a huge dollar amount bounty on someone's life. And then a few questions later, she's trying to act like they're isolated, and she didn't put them in there just because. She only put it in there to show that he had money and thought he ruled the world. Like, she switched it on the stand and then said she'd do it all again. So I really hope the jury's not dumb. And then the second moment is a body jumping at the chance to tattle like a 5-year-old about Kayla. KNW sigh and shaking my head. Yeah, before I even got to the sigh part, I got a sigh in the middle of your comment here. So for me, this is spot on. This is spot on. Oh, goodness. A whole mess. A whole mess. STS, thank you so much for sniping. Good to see you today. Hope you're doing well. Violet says, good morning, KNW Slime Gang. Good morning, Violet. Angie Lay said, hold on now. Angie Lay, you're here nice and early. Thank you so much for gifting a membership. Let's see. Chloe Albert's Revenge says, what will Hilton wear today? A towel, B, airplane chair upholstery, C, a shower curtain, or D, what the heck qualifies as unidentified? Oh, no. Oh, goodness. Goodness gracious. Yeah, this is exactly Paris Bridges. I think you spelled out a body's stand-up comment when he launched out of his chair, like writing it in words with emojis. I think this is the perfect representation because she's married to Mr. Jackson. Oh my gosh, eager beaver. Shout out to trial paralegal Regina. We love our paralegals. Thank you for the 2. Alice says, I feel for the jury. Can you imagine keeping track of all the mess the prosecutors threw out? Well, actually, Alyssa, love you lots. You have amazing insights, but I'm going to disagree with you here. I really don't think she knew it was about the diamond in his head. I think she seriously has a tunnel vision problem. I think she did not see it because she's so delusionally linear in her thought and the way she seeks things. I think she actually ignored it and kept it out of her brain space. That's how like delusional I think she is. I don't want to say crazy. I don't want to use the word crazy loosely. But I'm like almost ready to use it. So, she should have known. If she didn't know and wasn't willing to see it, she should not be an investigator. That's how I feel. But I seriously think she blocked it out, dumped it out of her brain if she did see it. And if she didn't see it, then she's not a good investigator because she had the notifications and alerts on. So just wild. Like, and I'm glad that Shart harped on that. And I'm glad that he harped on the scene city to sea. What a beautiful moment for her to switch what she heard right on the stand and then still try to insist that what she heard was the right thing. How can that be true if you just gave 2 different things? Just insane. And that was kind of a risk because it might not have gone that way for Shart. Right? I mean, I don't think it would have gone horribly for Shart, but for it to be such a gem or mess of a response to that line of questioning, just crazy. Yep, and the same thing, like, so what is being referenced here, well, there's 2 things, but who was Lisa R. and Don Geary, the bond hearings before trial started, in their arguments to the judge, to Judge Glanville, to deny Jeffrey Williams bond, even though Jeffrey Williams had like a whole schematic of how to have everything monitored, paying for it so it wouldn't be taxpayer money, all of this stuff. The state, like, 2 of the things that they hinged on were this Uzi Diamond thing being the capability that he could use 24 million to threaten a witness, right? They hinged on that to deny him bond. Then they hinged on this mall cop thing where they said he was hoverboarding around the mall security pressed him, followed him out to the car, and they claimed that he made terroristic threats to him, but he was never charged. Like, nothing came of that. But they were still trying to hold it against Jeffrey Williams because he said that I'm going to come back and shoot you in the face or something like that. None of these things ever happened. But you can see that the state has fixated on these things since 2022 at least. And that's just crazy. All over another artist who's not Uzi's not from the Atlanta area at all, right? He's got nothing to do with these individuals on a personal level. He's just another music artist, and Jeffrey Williams is a music artist. He gets something embedded in his forehead, and we want to change the words of what it means. We want to ignore that he says on his forehead. Like, what? Just a whole, it's really frustrating. So you either suck at your job because you're not seeing something that's right there. Because that was news when that happened. People were talking about it, and it was like within the same like 24-hour period. So how did you not see it? You're either a bad investigator, you're bad at your job, or what you're doing is a bit malicious, intentionally wrong. Sarah Maki, holy moly. Guys, let's show Sarah some love in the chat. This is 50 gifted memberships coming from Sarah Maki. So holy moly. Let's show some love. Green hearts in the chat here for Sarah. That's incredibly generous. Thank you so much. Especially if you guys got a gifted membership, make sure you're saying thank you. Probably a good time to do a banner. And again, I don't know. Let me refresh on X and see if we have a reason for the delay. Nothing really on X. Let's get a squeak sponsor. We got a bunch of squeaks yesterday from from Atkins. They gave him the chair. He has been the proud owner of that squeak chair for several weeks, it seems. Thank you for showing all the love here to Sarah in the chat. That was so nice of you, Sarah. And I always love that over on StreamYard, it doesn't give me, it just yells slime, like the name of the emoji, if it doesn't populate it. So my screen says bushes, slime, slimer. Oh, is it because like the bush is green too? So are you guys using the bush to, as in a green color? That's hilarious. Oh, we got some action, you guys. Oh my God, look at Paige's hair, you guys. She is ready for a day.
Okay, let's go ahead and get defense counsel. I know I've been just in chambers making some edits to the instructions. Figured it was easy enough to do that back there instead of here. Do you want to let are the defense attorneys back in that conference room? Well, they may not know that I'm here, so. Mr. Kendrick, did they let you sleep this morning? Okay.
You heard that, guys? They let Kendrick sleep. Oh, he looks, that's a good outfit. Happy birthday. Ooh, wiggly camera.
Good morning.
State's wearing gloomy colors, I see.
Is the verdict form that you were working on?
I just want them to say something loud enough so I can pull the captions up, because if I don't do it now, I'll get distracted and they'll be saying important stuff and we won't have captions until I realize the chat's saying, captions, cat, captions. They're never going to give me a moment to pull the captions up. I don't know his age. I don't know what age Yak is turning. Or I guess has turned. Brooklyn's on it. So I have a volume booster on, but I really don't think it goes to you guys. So I have my mic turned down. I can turn my mic down more so that way you guys can get it even with how it sounds to you with the court feed. So that way I'm not blaring out your eardrums when I speak. Oh, 32? That's a good guess then, Biff. We have 32. Yeah, the state is mourning their case today. 32. Thank you guys. Chat with the assist. So the feed has been like this for I think 3 days now. Because even if I force it to be the higher quality, it's still been the same. Ever since they had the first camera issue, whenever they got back locked in, it's just, it seems a little bit darker. And just different quality. I think a body is at the back table. Oh, thank you, YouTube watcher. It was detectives, district attorney, judges. And my bad, yeah, DT screwed with my brain there. I was like, what is this? A body's in timeout. He had a timeout after his ta-da moment. Yeah, I think that's a body right here. And the last thing the judge said to Ms. Persifield, I think, was just if they had the completed, well, not completed, but ready to start evaluating with both parties, suggested verdict form. So I don't know if we'll be right into verdict form stuff today, maybe.
Latest version of the charges. I did some further edits this morning, caught some things that needed to be said differently. So she's going to send that right now, and y'all can take a look at it. And did any of y'all have edits that you noticed that need to be dealt with? No, no. Okay. Okay. All right. So one question I had is, we've got conspiracy, the 2.021020, and then presence of the parties right now kind of set out also as separate charges, but I'm kind of, I don't know who requested that, but I'm kind of thinking we've already covered what those mean. And it may be that in our overt acts, there's a conspiracy to commit a crime that's an actual allegation, so that I would need to charge it with the overt acts. But do we need to charge separately, or does somebody want that as a separate charge?
You said conspiracy,
Yeah.
and what were the other two?
It's conspiracy, and then there are additional instructions about conspiracy, and then there's the presence, conduct, companionship before and after an alleged offense may be considered by you in determining whether they give rise to an inference of a conspiracy.
I don't think we need any of that.
I mean, I feel like we kind of already explained, here's what conspiracy means within the RICO statute.
I think that's correct. I agree with Mr. Sharp.
Okay, state
No objection, Your Honor.
to taking those out?
Correct.
Okay. All right. So another thing we need to do, now that we just have the 106 possession of a firearm by a convicted felon, that does have a pattern. It's really simple. It's just for possession of a firearm by a convicted felon, the state must prove the defendant possessed a firearm after having been convicted of a felony. And then there's a blank to say these particular things are felonies. So I don't know what the convictions of these two defendants are that have come in right offhand, but I would think that that's what's supposed to get listed in the blank.
I think probably whatever convictions are listed in the indictment as the predicates for the possession of firearms would be the ones that we would list there.
Well,
And
are those convictions for these defendants in? I thought that was the whole,
Yes, Your Honor. So the underlying convictions for at least Mr. Kendrick is in. Your Honor, the underlying conviction for Mr. Stillwell, that is a conviction that I was looking for right before the state rested its case. I was going through a folder, it's supposed to be exhibit 34Q. I do not see 34Q inside of the documentation that is sitting there. That's the only exhibit missing. And so we are trying to find 34Q. I believe the court said that
I did.
we can open it up for that, that limited purpose, but that is the exhibit that we've been looking for with the 34Q, which is the 15SC. I think the last digit ends in 6. I don't remember the entire indictment.
Have you gotten through all of the evidence?
Not since not since Monday or Tuesday when we rested, to determine if it's.
Okay. So, all right, you just hadn't checked yet?
Yeah.
Okay. All right, so for Mr. Stillwell, it's the felony that he's charged with in count 52 as having already been convicted of is actually also possession of a firearm by a convicted, 2 counts of possession of a firearm by a convicted felon, a 15 and a 19 SC. Is that your understanding? Okay. Well, that's not charged in this indictment, in this count. So I guess then what we would say there is crazily circular. Possession of a firearm by a convicted felon is a felony. He's charged with two counts of that. Mr. Kendrick's charged with? So looking at the possession of a firearm by a convicted felon charge against Mr. Kendrick, one of his alleged prior felonies is also possession of a firearm by a convicted felon, but the other one is possession of a firearm during the commission or attempt to commit certain crimes. Do y'all know what that was specifically? Like, was he specifically charged? Was it just during the commission of a felony? The way it was charged?
Yeah, he was charged in 15 SC 140116 with possession of a firearm during the commission of certain felonies, which would have been participation in criminal street gang activity, conspiracy to commit.
What did he plead to, though? I thought the gang, y'all drop a whole lot of gang counts, it seems like.
No,
So-
in this indictment, he pled the conspiracy to commit a crime, which was aggravated assault. He pled the criminal street gang activity, possession of a firearm during the commission of a felony, theft by receiving stolen property, purchase, possession, or having control of a controlled substance in Schedule 1 or 2, excuse me.
Okay, I'm just going to say possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are
Yes.
both felonies. Okay.
Thank you.
I don't know if there's, so we'll have to figure out what the verdict form is going to look like before we can figure out exactly what we're going to say with regard to how they walk through the verdict form. We also need to take another look at the overt act charges and make sure that everything is included that needs to get included that hasn't otherwise been defined in these main charges. So do y'all have a copy of that you can look at?
Yes, Your Honor.
Okay.
This is the copy Ms. Percival circulated at the end of the day yesterday?
Yes, I don't think it's changed since then.
There have been some slight changes to it.
There are some slight changes.
Do we have the slight changes yet?
No, because we were going through it literally minutes ago. But I can screen share that if that's the easiest way to do it.
I think so.
Okay. Yes.
I may have spoken real quickly. The three conspiracy charges.
Yes.
you have On 18, I've checked those against what you have in the RICO. The only thing that's in those that's not in the RICO that I think should be part of the conspiracy
Okay.
charge is conduct of the alleged conspirators. That's where it stops in the RICO. I think it'd be appropriate to add the words before and after the commission of the alleged offense, because that's an integral part of the conspiracy charge. Otherwise, I think everything that was in those 3 charges, you're correct, is captured earlier in the RICO.
Okay. So what are the offenses, though? You know, like, I think we kind of got hung up on that yesterday.
Well, that's, we're talking about the RICO conspiracy. That would be the commission of the offense that you're talking about.
I mean, I could just say any alleged offense.
Yes, before and after the commission of any alleged offense, yes. Instead of the,
Yeah.
that makes sense.
Would that work?
Yes, Your Honor.
Would that work for the defense?
Okay with it? Yeah, that's fine, Your Honor.
Okay,
Thank you.
thanks. All right, so with regard to the overt acts, what I was planning to say after I define overt act, so it'll say overt act means an outward act made in furtherance of a conspiracy. The overt act may but does not have to be a crime in and of itself. I was going to say some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined. Does that work?
Yes.
Okay. All right, have y'all together coalesced on any type of verdict form or?
I think coalesced, no, we have not coalesced on a jury verdict.
All right.
Coalesced as in us in the state?
We're maybe closer to congealing than coalescing.
Well, if y'all congealed
Yeah,
on a
they have
verdict
it.
form.
We've prepared one, we've circulated it to them, they got it this morning a few minutes ago. We have not had the discussion yet.
Okay.
The best way to proceed may be to throw it up and then on the screen, and then
Okay.
we can discuss the edits we would like to see.
All right.
That works for Mr. Shard.
Okay, and I don't know. Are y'all ready to do overt acts? The overt acts definitions? Or no? Yes?
We could do that and come back to verdict form, yes.
I mean, we need to do them both.
Okay, any
So-
order the court would like.
It doesn't matter to me. Okay.
Thank you for that command decision, Mr. Shard.
Ms. Persefield is like, y'all are all over the place this morning. Wait, that's all any of us wants.
She had a Christina Weaver expression at that point.
All right, do you have it up on the screen? Okay. All right, do we need, so firearm is a deadly weapon, that needs to get charged, but that isn't like a separate charge, right? I mean, I do think that for these overt acts, it would be helpful to leave like assault as a heading if one of the crimes is assault.
Or maybe, I think assault's in there, Your Honor, because one of the crimes is aggravated assault, so, and for aggravated assault, you need to define assault.
Okay.
So maybe,
Well, if it's only aggravated assault, then let's have, can you switch it to say aggravated assault? And is it aggravated assault with a deadly weapon that's the overt act?
Yes, Your Honor.
All right, So that'll be to prove assault. So I think underneath there, we'll give the definition of assault. A person, or assault means to commit or attempt to commit a violent injury to someone else.
Yes.
All right, does that work, the way we have aggravated assault now?
Yes.
And then do we have simple battery, or how is it listed?
There's an aggravated battery.
Okay, so that would be the same kind of thing then. Well, I don't know that we need the definition of simple battery because aggravated battery is kind of its own definition. You have to actually cause bodily harm. So do we have any simple batteries in the overt acts?
No, Your Honor.
Okay. We have terroristic threats.
Yes.
Was it from the person or from the immediate presence? Or do you want both?
That was, Arabia Hill was a car, and I believe a purse that was in the car. So that would probably be immediate presence.
Okay.
That's correct, Your Honor, in terms of that overt act 61 says from the immediate presence.
Okay. All right, and then we have a theft by receiving stolen property.
Yes, Your Honor.
And is it all of those things, receives, disposes of, or retains?
I think receives or retains.
Y'all okay if I just say keeps?
Oh, yeah.
Oops. Do we need to define receiving? I don't think so. Unless, I mean, don't y'all think everybody knows what the word receives means?
I think so.
Okay.
Let's ask Viverito.
Should we say alleged perpetrator?
Instead of, yeah. Well, are we saying alleged perpetrator?
I thought we were saying alleged perpetrator. Are we not?
perpetrator.
Just perpetrator? Okay.
Oops.
I mean, they did kind of say that yesterday, but I guess maybe for one clause.
Can you do a global replace of defendant for perpetrator? And we can get rid of that if there's any reasonable doubt, because that's not relevant for here.
And the reason they have to change defendant to perpetrator is because some of these could have been committed by like the severed co-defendants that aren't in the room or have already pled out. So it would be misleading in a
Right.
prejudicial way
Possession of a machine gun look okay?
for them to read all these things as if it was about Yak or Stillwell.
Excuse me, in theft by receiving, the last paragraph says goods. I think everywhere else it says property. Maybe say property, just to be consistent.
Well, it says goods in
It
the second
says
paragraph
goods.
too.
That is one of the pattern charges that has not gone through a plain language rewrite yet, so it's all over the place. Yeah, but I mean, we can say property was,
You say goods in the first sentence as well of the second paragraph.
let's say the pattern says.
Oh, that's okay. I'm sorry. The pattern. You're on.
We okay with this one? All right, possession of a firearm by a convicted felon, I think I'll just lift we already have that defined in our substantive counts, right?
Correct.
All right, so the question is, some of the other acts, crimes will have been defined already. But for instance, the fact that we have possession of firearm by a convicted felon in the other acts as well, is there a preference for whether it still gets listed in this appendix and just said that's already been defined, or not listed at all?
The state would request to say, to list and to say as previously defined.
Okay. All right. Okay. All right, so this one will just say previously defined.
And this will all get cleaned up so it looks kind of the same.
And there'll be some others we have to add in there, I would think, but. So on the possession with intent to distribute, we've got various different substances, I think. Do we want to list all of those that way, or just say the substance?
Yes, I would just say the substance.
Okay. Well, so we'll get that fixed. All right, criminal gang activity. Well, yeah, a bunch of these are already. All right, so that's it that we've got. What else needs to get included from the overt acts?
I'm going through around what I have.
Okay.
1 minute, I'm on.
All right, great, thank you.
Judge, there's a couple in here that don't have a header on them.
Okay.
That would be sale of marijuana.
Okay.
There's two that are the possession by an inmate.
Oh, okay. I did not,
Sorry, they
yes,
don't have- they don't have
okay,
headers on them.
okay. I see them now. I'll just kind of bold them for now. Are y'all okay with, everybody okay with how those two get defined?
Yes.
Yes, Your Honor. And Your Honor, I had one
Yes.
thought with the consolidating the controlled substances.
Uh-huh.
Could we have one sentence that says, for any of these substances, MDMA, methamphetamine are controlled
Controlled
substances?
substances, sure.
Yes, Your Honor. Thank you.
Can you do that, Laura?
I think
Is the defense okay with those two ways that possession of a weapon, possession of telecommunications device by an inmate are defined?
Give me just one moment, please.
Yeah.
And Your Honor, my list was not exhaustive. Any of the controlled substances like oxycodone that we have, we could just have one sentence with all of those substances, are controlled substances, because each individual one lets the juror know.
Yeah, that's fine.
Okay, thank you, Your Honor.
I would,
The jail part?
yes.
Yeah.
I think, my personal opinion is it should follow the text of the statute a little bit more and be less specific about while incarcerated, the inmate in Fulton County
Yeah.
Jail.
It's only in Fulton County. Yeah, that one's a little bit, what does it say? Out of jail or out of correctional? What does it say? I mean, at a jail? There are all these different definitions. I don't know, let me pull up if anybody knows, can give me this.
42,518.
Okay, can you read what it says? I don't have Lexus up yet. Well, it really says while an inmate.
So I guess we just put while an inmate.
Okay. Wow, an inmate. I'm happy to say out of jail if y'all want, but
No, just while an inmate, I think is fine.
Okay.
Your Honor.
so question. I would just think possessed and not was found in possession of. Thoughts on that? It's kind of what the statute
Yeah.
says.
Okay.
Whenever, of course, ready.
Yep,
I
we're
think
ready.
I found, so what I believe we are missing it depends on how we want to do it, is attempted murder,
Okay,
murder, and then conspiracy to commit murder, and conspiracy to possess a telecommunication device by an inmate.
Was that a conspiracy, the last one?
The last one with Mr. Garlington on the phone with Frank Hubert and Quantavious Greer.
Is that charged as one of the overnights?
Yes, that is count one, I mean, excuse me, not count, act one. $179,
so conspiracy to possess a telecommunications device?
yes.
So we have Your Honor, we have a possession of telecommunication device by inmate and a conspiracy. Because 170 is possession.
Okay, so conspiracy to possess a telecommunications device by an inmate?
Yes. That's because they
Is
were on
the conspiracy by the inmate who was trying to possess it, or alleged to be by someone else, like helping them? You know what I'm asking?
Yes, it was helping, they discussed possibly flying the phones in the jail through a drone.
You know,
179.
okay, so that would be then, like B1, it's unlawful for any person to procure or give an inmate a telecommunications device, right? So it's a conspiracy to do that, right?
Yes.
So conspiracy to provide right?
Well, conspiracy to,
I mean, the statute is not, the statute's called items prohibited for possession by inmates. And part of what is illegal within there is for another person to obtain, procure, or give an inmate any prohibited item. So how do you want me to say that? Conspiracy to provide a telecommunication device to an inmate?
The problem is they cited a certain section in the overt acts.
Well, how did they say it?
They said, in the overt act, it says, Tameka, Garlington, and Quantavious Greer did unlawfully commit the felony offense of conspiracy to possess a telecommunications device by an inmate.
And then described it as how?
When, while speaking over a cell phone to an incarcerated Fulton County deputy, discussed a plan to fly a drone carrying cell phones beyond the guard lines to a window
Okay.
at the Fulton County Jail, in violation of 42-518.
both of those individuals were out of jail and they were,
It does, okay, I understand, but that's not really a conspiracy charge. That's a violation of this statute. But I guess because they didn't actually achieve it, then, okay. Conspiracy to possess a
or to provide.
well, y'all said possess. Conspiracy to a telecommunications device. All right, let me just say. Y'all can be coming up with language for whatever the next one's gonna be.
I think the only two that it appears will be the attempted murder and the conspiracy to commit murder,
All right, well,
based on what I have.
figure out the language while I'm working on this one.
Okay.
So am I going to need to define conspiracy? Or can I just say attempts to? So we're not actually like finding anybody guilty of these things in counts or anything. Y'all tell me.
I agree, Your Honor. I don't think we need to define conspiracy. I think you could just put,
So could I just say, a person commits the offense of conspiracy to possess a telecommunications device when that person attempts to provide an unauthorized telecommunications device to an inmate?
yes.
Okay. That okay with the defense?
When that person,
Attempt to provide an unauthorized telecommunications device or cell phone, I can just say cell phone, to an inmate.
this might be putting a word in the definition, but why wouldn't we put conspires to? Because it's not an
Why
attempt.
wouldn't we put?
It's not an attempt, like,
Okay, I don't have the definition of conspiracy in front of me anymore. I'm happy to say it however way y'all want.
I'm not saying we need to define conspiracy again, but instead of saying when a person attempts to provide a,
Uh-huh.
why wouldn't we just say when a person conspires to?
Well, I guess just because I was taught you never define a word with the word. But
I understand, but to me, we're
we can,
describing a.
I'm fine with that.
We're describing a crime.
Fine, conspires.
It's just because attempt is another.
Fine with me.
legal term.
There.
Can we,
Up.
Okay, that's fine.
I have the conspiracy charge, so
Okay.
a person commits conspiracy to commit possession of a telecommunication device by an inmate when that person, together with one or more other persons, we're going.
Oh,
back to
down,
what
Hilton.
Mr. Shar just said, though, conspires to commit.
Okay.
Mr. Shar.
A person commits the offense of conspiracy to possess a
The word
telecommunications
commit
device
is beating them
when
up.
that person conspires with someone else to provide an unauthorized cell phone to an inmate. Good with everybody?
That's good.
Oh, yes, Your Honor.
Okay. All right. All right, so then we need,
That's Bob.
we will have listed, are these getting listed in the order in which they come as overt acts ultimately, I guess?
If we can, yes.
Okay. So somewhere we'll already have murder. And then we'll need attempted murder?
It seems to make more sense to put them in alphabetical order just because you don't know if the jury may be going back, jumping
I
around,
don't
but
care. We just
whatever.
need to decide on a way. Yes.
I was going to say for the next attempted murder, just to cite the pattern instruction 20110, but I think whether it's chronological from the overt acts or alphabetical, either one is,
Attempted murder ought to come after murder.
yes, Your Honor. And because we define murder, the jury will have already been instructed on it for the counts. When attempted murder comes up in the overt acts, I think all that needs to be defined is just attempt, and then murder is previously defined,
Right, okay, so we'll define attempt.
which
I
I
like
have that
that.
instruction is simply a person commits criminal attempt to commit insert offense, in this case murder, when with intent to commit, that person performs any act that constitutes a substantial step towards the commission of the crime.
Okay, where did you get that from? Where could I
Your Honor,
lift that from?
the pattern instruction is 2.01.10, attempt statutory definition from the pattern instructions.
Oh, one, perfect. Okay.
And Your Honor, the only other attempt I believe we have is the attempted armed robbery, which is Act 5.
I like that one.
But we will be defining armed robbery in these overt acts as well.
I'm sorry, but where oh, okay, I was looking at the wrong charge. So I think maybe we just do attempt to commit a crime, and then they can reference it for both of them, right?
Yes, Your Honor.
So we're just doing intent.
Yeah, I
By
think so,
itself.
yeah.
That's what I have up. You see what I have, Judge?
No, I don't, I was totally doing my own thing. Does that work for y'all? What's on the screen? I think say with intent to commit that crime instead of a crime.
Yes, Your Honor. Stated here.
Yeah, okay.
And should this be criminal attempt or just attempt?
Probably criminal attempt. All right, so conspiracy to commit murder would sort of be like our conspiracy to have the telecommunications device, right? A person commits. Where is that? Where do you have?
Okay, this is not quite right, but.
Let me see how murders. I mean, we could just say the crime of murder. To cause the death of another person unlawfully and with malice aforethought, or, I mean, is it just, it could be, can you attempt to commit felony murder? I guess. Beats me.
I'm thinking through, Your Honor. I don't think you can.
No? I mean, we don't, do we want to just say murder, or,
Yes, Your Honor.
or do we want to say cause the death of another person unlawfully with malice aforethought?
I think just murder, because we would have already defined
All
murder.
right. Certainly. I think that's fine. Everybody all right with that? The way that's defined?
Yes, Your Honor.
Okay. All right, do we think we have all of the, other than the ones we need to just add and say, you know, this is already defined? We think we have everything?
I sent an email, I apologize. As it relates to aggravated battery, the malice definition is different than the malice for murder. And so it's usually given underneath aggravated battery as it relates to
Okay. Is that part of the pattern charge?
It's 2.22.31, Your Honor.
Thank you. I can,
I have it, Judge.
okay. I think just drop the whole thing in there and,
I just dropped it in there.
yeah.
It does, I don't know if it all needs to be.
Do you want that first sentence? Does anybody care if we have that first sentence or just start with malice in this context means?
I think we can start with malice in this context means.
Except it says maliciously, not malice.
Ah, yeah. Okay, we'll just leave the whole thing. Anything else on these? Okay. All right, I think we better turn to the verdict form then.
Oh, finally, verdict form.
All right, so I know Ms. Percifield had taken kind of, I think, I don't know even whose it was, but somebody's from yesterday and started working on that. And then I know we've got new proposals from the state and from the defense, is that right?
For the verdict form, no, I have complaints, but no proposal, but
I sent some edits in. I have additional edits, but I know I sent one form in with edits.
All right.
But that was prior to the most recent version from the state.
I mean,
You guys are all on this rivet in her hair. Chloe Albert's Revenge says, do y'all see that ribbon in her hair? Y'all need to get it together. Don't you make Miss Whitaker late for her dance with Steve Rogers. Okay, Atkins is like super squeaking today. I'm behind on the squeak counter. White Turner said, Judd said she got the streamers in her hair ready for this birthday celebration for Yak. That is a very green tie for a body. He's wearing like a slime tie today.
And this language is lifted from the charges that we all looked at yesterday.
Should I just start making some comments? Or?
okay. This is from the court.
it's, yeah, I mean, it's a draft.
On the last sentence that says list each overt act and or pattern of racketeering activity to which you all agree, I believe that we at least need the word, well, I would like the word unanimously before agree. because the pattern has to be unanimous.
There we go. That was a big question in the chat from yesterday. They talked about this a little yesterday.
I'm still looking, that's just one that jumped out.
Now, we're going to do a lot of two timings. Because we don't have them read the whole text while they're debating it, what we're going to do is we're going to pause. We're going to read what's on the screen. We're going to 1.25, 1.5 to see what they argue about changes. That way we know what they're talking about. So right now, this is verdict form. It's the very beginning of the form. Count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act. Again, conspiracy to violate. We, the jury, find that the defendant knowingly and willfully agreed to join a conspiracy, understanding that one or more conspirators, himself and or a co-conspirator, would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to either 1, get or keep money or other property, or 2, participate in the enterprise. I thought they changed this yesterday, but I guess they didn't. And the state must prove that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. List each overt act and or pattern of racketeering activity to which you unanimously all agree. So they've got to do some work here. That's what we're going to be working on. And they'll go through this form for Stillwell and for Yak separately.
And then, Your Honor, under this form, either be yes, no, or how would they?
Honestly, I'm not even looking at it right now. I'm sorry, give me just a minute.
Yes.
That's a good question.
Oh, John Floyd's got the squeak? We treat our guests well here. And personally, I think the verdict is super important because that's where you think this is exactly what you're being asked. You may refer to the instructions as kind of like an index for definitions, terms, further explanations, but the wording on the verdict form is extra, extra important.
Yeah, there's got to be some way they can agree or disagree with that.
Maybe, on the question of,
Go ahead.
maybe something like on the question on has the state proven beyond a reasonable doubt that the defendant knowingly, and then, so you start out with like on the question or something to that effect, and then the options would be not guilty and guilty.
Great call by Marks. All right, we'll do the pausey thing. So with the wording now, MacShard is suggesting, hey, let's change this wording that currently says, based upon the foregoing findings as to count 1, we, the jury, find the defendant guilty or not guilty. And Shard is saying, after conferring with Doug, it seems like it's both their suggestion. Can we word it as, we believe that the state, beyond a reasonable doubt, with that standard, do we find guilty or not guilty? Very big difference there.
So, bear with me. The sort of concept that we, I think, settled upon last night was that they needed to be unanimous that there was a pattern of racketeering activity,
There would be a pattern.
that a defendant agreed to having somebody commit a pattern of racketeering activity.
I hope she does a yes check.
So
If you
maybe,
checked yes to all, then you may find.
do you agree? Do we want them, I don't know that we want them having to say, I think that as long as they are instructed let me start entirely over. So once we got to the verdict form, I was going to say for count one, the state must prove that the defendant knowingly and willfully agreed to join a conspiracy, understanding that one or more conspirators, himself and or a co-conspirator, would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to either get or keep money or other property or to participate in the enterprise. And the state must prove that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. To be unanimous on this count, you must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. You do not have to be unanimous as to specific acts of racketeering activity. You must also be unanimous that at least one overt act was committed after May 10th, 2017 to further a criminal objective of the conspiracy. And then I guess, if you determine that the state has proven all of this, or if you're unanimous as to all of this, you should note on your verdict form any overt acts that you all agree to.
As well as the pattern of racketeering activity that they unanimously agreed to?
I mean,
Was it a question, or that was a request from me?
Maybe after that first part, which I agreed with and liked and feel that it's an accurate representation of what needs to be proven, that's where we put in the options, you the jury or we the jury find guilty or not guilty or guilty. And then afterwards, if guilty, identify the predicate act. Okay.
Identify the pattern of racketeering activity that you unanimously agreed upon.
And additionally, identify the overact
After that date.
after
May.
that date, act with the S potential,
well,
and then
any overt act.
After May
And they don't-
2017.
Well, we can figure out whether they occurred after. I mean, they've been told that if they're going to list any overt act, then they should list any overt act, not just the overt acts after that date. And then we can figure out whether one of them is after that date.
Every one of them in the indictment has a date attached to
Okay.
it. Your Honor, if I may.
And y'all had asked either by act number or otherwise, right?
Well, actually, since yesterday.
Yes.
This is going a little bit in reverse order. But the concern that I expressed yesterday was, I think the phrase at that time was, note on your verdict form any overt acts. And in thinking about that, and given that the court's inclination is to tell the jury that if they find overt acts with all the attached requirements, they should list them, is kind of asking them. I don't know what we're going to get if we just say list it. I don't know how they're going to interpret it. So when we sent a verdict form this morning, what we did was attach a list of all of them with a line they can check and to signal that they find it. And just a brief instruction above that says, please check below every act in furtherance of the conspiracy, which all 12 of you unanimously agree was committed by one or more conspirator. Honestly, I don't think we have to say both all 12 and unanimously. I think either one is fine. And so we would have, I think we just say unanimously agree. But that way we'll know, they know to begin and they know to end. They know to do the entire exercise. there's 190 as of this point in time, I believe. They go through all of them. They check the ones they find if they find it. That way we don't have them quit early and we don't have them kind of create their own form. I'm very concerned about the opportunity for confusion that presents.
Well, if we're going to use any version of that, it needs to say any act and not every act.
I understand, I get that. You're not instructing them that they have to find an act, I understand that. But this will give us the answer. I mean, if they are going to be told to designate, report those acts they find, then I think a form that takes them through all of them will get the answer. We'll get their answer to each one.
What are the highlights?
Those are acts that may need to come out.
Y'all haven't decided on those yet.
Yes.
Defense?
If they come out, that would only,
Okay,
that would just, we
All
just have fewer. is
I
all, but
understand.
The principle remains the same.
I prefer the proposal that Your Honor was putting forth. If we use the checklist that the state has put forth, I think it needs to say, please check any the overact with the possibility for plural S, if any, which all 12 of you unanimously agree beyond a reasonable doubt was committed by one or more conspirators.
And I also prefer the court's original suggestion over the checklist.
So,
But
Your
if-
Honor, I don't think we need beyond a reasonable doubt again. You've already rejected the idea that we have to put that in everything
Yeah.
all the time. They'll be clearly instructed on that. And then,
I just really don't like the instruction, check below every act, because it just indicates that there is at least one.
I
the
agree.
state agrees. If
We would
if the
definitely
word is
change
any,
that
we have
language.
no objection. So we can take care of that one. And then I have a little more, but I just wanted to explain that list that we've appended here.
All right,
and
well, I'll
logic behind it.
consider that. Is this in Word form in our folder, Laura?
It's not saved in the folder because it just got sent over this morning.
Okay,
I can save it.
all right. What else, Mr.
The,
Floyd?
Thank you, Your Honor. If we could display the version we had up before, because I didn't have a copy of it otherwise.
Well, you can talk about it. I'm looking at it, whether it's
I know,
displayed or
I
not.
just I don't have the words in front of me.
Oh,
In the general premise here, Your Honor, is that I think there's an awful lot in there, and it's.
oh, I hadn't even looked at what was, honestly, that's just something, yeah, I'm not going to write it like that.
Okay.
It is not, it's going to say count one RICO. Now, I guess it doesn't matter whether they find subsection A or subsection B, as long as they find one of them.
That's correct.
But they all have to agree on the same one.
No, they have to agree, that.
They have to unanimously agree that it was committed in one of those ways.
But
It could be either or both.
But they all have to it couldn't be 6 on one way, 6 on the other.
I don't know. Does anybody know the answer to that? I mean, it's not like in any kind of an aggravated assault case I've ever said, you've got to pick and tell me, did you think that they were, in reasonable apprehension, or did you think some other way?
You're telling them that they have to find they conspired to violate the statute, and they could have conspired in one or both ways, and you're telling them they have to be unanimous. I don't think we have to tell them they have to be unanimous on everything all the time, just like we don't have to tell them that the proof is beyond a reasonable doubt. That is ultimately my concern, because yesterday we spent a lot of time going over your instruction on as it's expressed here, the 7 elements of each of these two. And they've got that, and they're going to take it with them out. So re-expressing this in some way here is never going to exactly match that. If it did exactly match it, it would have no purpose. And if it doesn't exactly match it, it opens the door to some confusion.
Do they have to unanimously agree? Assume they only find one. Do they have to unanimously, all 12, say, yes, it was the conspiracy to violate subsection A? Or?
Number one, no case on it. Number two, if they find both, if they're unanimous as to both, it doesn't matter.
I know.
If they're
That's
not,
why I'm asking if they're not.
I'm just I understand.
Okay.
I'm thinking it through. With
All right.
That's all. If they do not find one, they're not unanimous on one, they would have to be unanimous on the other. If they
Okay.
find both, if they're unanimous on both, it makes no difference. There's nothing more for them to do.
So just ask for them
then
to be
I think it
unanimous.
has to be listed out as subsection A and subsection B. If everybody agrees, they have to agree, all 12 of them, it's A or it's B.
So it would be, do you find them guilty, not guilty as conspiracy to violate A?
Yeah.
Find them guilty, not guilty
Yeah.
as conspiracy to violate B? We don't object to that.
But I disagree with the state in that I do believe that at least having the word unanimous in there would be helpful to the jury, because I really, talking about confusion, I think the racketeering statute is so complex, just to put the word unanimous in isn't
I
that
hear
big a
you,
deal.
but I'm going to tell them, everything you check on this verdict form, you all 12 have to be unanimous about.
And Your Honor, if you're editing the document now, can we view that or?
I'm
Oh, okay. Yeah, we can't view that.
I'm old school writing it down. I don't even know, honestly, which of the documents to use because I don't love any of them. So,
Just to be clear from the state's view, I think if we had the one we had submitted said, count one, we find the jury not guilty or guilty of conspiracy to violate the Racketeering Influence and Corrupt Organization Act. Based
would
on
just
the
say
conversation we just had.
subsection A.
Yeah, and then a second one, subsection B.
Yeah, and they'd both be under count one.
And I think you would want to say the jury can find them guilty of
Yeah,
one, both, neither.
yeah, agreed.
So that they don't think their job is done if they just check one, because
Yeah.
we want that answer.
All right.
But I think with that and the chart on overts, everything that needs to be known is known.
No, because I think since they have to be unanimous on the pattern of racketeering activity, I think that they need to identify the pattern of racketeering
I
activity.
mean,
I can't disagree more.
I understand both of your positions. I think that I will have them, like the one that Ms. Persfield had displayed first, I think, have to say they are unanimous that a pattern,
That would have been.
whatever, however we're going to say it. But I'm not going to have them describe the pattern. I mean, we'll have sufficiently explained it to them. They can just say, yep, we're unanimous.
Okay.
When you asked me over the last couple of days about cases that have used verdict forms that say more than guilty, not guilty, what I've just talked about on behalf of the state, I've never seen one go further than that. Guilty, not guilty, and if there's a question about which predicates or which overts, predicates in a substantive case, overts in a conspiracy case, That's it. I've never seen one that asked any more of the jury.
All right. Well, I think I'm just gonna sit with all of the
Wait.
proposed verdict forms and put together something that I think makes sense and then show it to y'all later.
Let me lodge a last complaint
'Kay.
before you sit down with them. Also with the states, I don't think I said this, but with the states checklist,
Mm-hmm.
I don't know why we would be sending out checklist options for things outside the statute of limitations. They can't justify. I mean, we're giving them options to check things that legally
Yep, you need to specify.
cannot support a
Well, if that's
conviction.
all they check and they don't check one that's after May, whatever, then
Okay.
I don't know if I'm going to use the checklist, but if I do, it's going to have everything that goes out. All right, so I will work on a verdict form, thinking about all of the different things we've just talked about.
She's taking over the group project.
Y'all need to figure out what evidence goes out and what evidence doesn't, because if we're taking, the rest of today and then we're taking tomorrow for y'all to have a work day.
Oh, no court at all tomorrow?
Once we close and I instruct, I don't want to take 2 hours to figure out the evidence. That needs to go out when they walk out. Y'all understand?
Yes, Your Honor.
Okay. All right, I'm going to step off and we will be in recess, but y'all stay here and work on all of these various things.
I don't know how long that break is going to be. That could be a decent chunk of time here. So this might be we gotta do some improv today, guys. She could be back pretty quickly. I think, I think maybe she was just, camera. I think she was just looking for an excuse to be like, all right, you guys stop giving me the ideas. I'm just gonna take over the group project. So, we can come up with some ideas. If there's a particular thing in the trial you want to revisit, we can do that. And of course, you guys know I'll keep this window up so when they come back, we can toggle back and forth. But it sounds like there will not really be court tomorrow. If there is, it might be mostly recess and an occasional judge tidy something up. So we'll see. It's a wine break. Everybody get your wine. Also, Chloe Albert's revenge. Yeah, so I did see that, Thug is being sued. It's a suit that I think it was like AMG brought against him in 2020, but they're renewing it. They're like prodding at the court again because he's now no longer in custody. But it was for what they claim is a violation of exclusive performance contracts that they had with Young Thug. So it's not exactly a new lawsuit. It's just renewed because it was on pause because he was not available. He was not available. He had some stuff going on. So if you see news about him being sued, like, don't go thinking it's like a civil suit relating to this case. But great thing to note here, Chloe. Ray with the 20 says, the only thing we missed in this whole mess is mistrial bingo cards. Well, nobody ever could have won. So, next case involving the clowns at the prosecution table should have it. Yeah. Print them out. Put it in the, you know how some binders have the, clear slip that you can keep a paper sheet in the front of it? Just have their bingo card right there in the front. That'd be a good time. Matthew Payment out here sniping with the gifted membership. Thank you so much. Turning someone green out here. STS's burrito failed. Connect the dots. Well, yeah, she just did the whole, you got all the dots here. She just goes, boop. I'm gonna go right here. And if you ask me why I missed these dots, I'm gonna be like, well, I just put in what I thought was relevant in my folder. So it's fine. So you skip things? Correct. Just a whole mess. Not the way to play connect the dots. Touche says, I think Paige was also mad at that part with Viverito too, because she barked and overruled at Hilton's objection. Yes. And Hilton tried 2 or 3 bases there. She's like, objection, vague, something, something. I don't know specifically at this point. But Whitaker was like, overruled. So, womp, womp, womp. Okay, we could redo opening statements. Do we have to rewatch Adrian Love's? Do we have to do it? Do we have to do it? Oh my gosh. Do we have to do it? I know you guys are going to go crazy looking at that sleeve that's like here. Everyone's like, no, 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 no. We can do the defense's opening statements. Yeah, we get the summary. If you guys want the opening statement from the state, just watch Jungle Book. Or read Jungle Book. NJB Nene out here dropping 10 gifted memberships. Let's show NJB some love in the chat. Big thank you here, dropping 10. Okay, yeah, that's actually a good point. So we could just do Yak and Shannon's. Jay Apt did openings for Diamante Kendrick, and Max did openings for Shannon Stillwell. So that'll be good. We'll get some Jay Apt. A little crossover here today with the co-counseling. That's a good idea. Monica, thanks for being a member for 2 months. You're saying thanks a lot. Well, thank you right back. Paula Rivera, thanks for becoming a member. Yeah, Aaron Olivia, sometimes I'll be looking at the chat and missing it, but I know Yak gave a heart sign over to the camera.
Consulted, what we're going to do is the attorneys are going to stay here and work, but we're going to actually adjourn court for the day. We will not be in court tomorrow. We will be back up at 8:30 on Monday. And y'all are going to get lots of work done in the meantime. All right, thanks.
She's speaking to us. We got to be productive tomorrow. She said we're going to get work done a whole day. So with that being said, I mean, we can still do openings of those two attorneys. I think we can lock in and do that. We did rewatch them fairly recently, but at the same time, I mean, I'm telling you, I'm always going to use this analogy of stocking the grocery store shelf, fully stocked with Campbell's soup cans. And you have another can, you try to put it in, you think you're doing good, and then it's really pushing a can that you're not paying attention to off the shelf. You can only keep so much top of mind at one time, so I don't mind rewatching those. I just didn't want to sit there and get mad watching Loves. A whole mess. So we'll do that. Anthony Samora said she looks so tired. I think this is Paige, right? And I really do think, and even for the state, who I don't really think too many members from the state are working outside of their 9 to 6, which I think is different for the judge. The judge has to have found time to go and read up on RICO stuff in other states, right? So I can imagine she's tired. I can imagine the defense is tired. The state, I can also imagine that they're probably getting to that point too. So this is just a crazy trial. But it's very apparent looking at, like Whitaker. She's tired. I know people were saying she looks like she's aged a bit, but you know, sometimes good rest, you can come back reversing all of that. It could just be temporary. But definitely looks tired. I also, before we start watching these opening statements again, I mentioned in the chat, but Excited Utterance, friend of the channel, you usually see her in here. She's got a cool like graphic type picture. It's like muted white, gray, and red. She's covering an Aussie case, an Australian case later at 6 p.m. Eastern. So that's a ways away because this is ending early. I would have redirected over there. But I want to say it out loud because it's really cool to watch court go down in other places. So she is actually from Australia. It'll be great to watch it through her. And it's a situation where police officers tased a granny. So it's being called the Granny Taser Trial. So really interesting if you like to watch cases and kind of want to see another country. Really cool. I don't know, it's just a little bit different, right? And seeing the differences is really neat. So let me get that link again. But wanted to say that out loud. And then also tonight, I saw that Flesh of the Gods, he's going to go live tonight. It's Thursday, but specifically his topic is going to be the infinity testimony. So testimony about this infinity with the Donovan Thomas murder. So if you missed some of that stuff, it looks like he's at least going to go through that witness that is an infinity expert because he's driven one and also sells cars. So he identified something that was not visible on the camera. He's going to be going over that again. But just dropped excited utterance in the chat. And then for that rewind with Flesh of the Gods, that will be after excited utterance. So the whole TV lineup, if you will. I think that's actually a really good rewind because Donovan Thomas, we haven't heard much about that. We're going to hear about it in closing argument. It's a good way to get refreshed. And there's the Flesh of the Gods link there. So, just some things I wanted to highlight in case you guys are going to get out of here and not stick with us for the rewatch of the opening statements from counsel for Diamante Kendrick and Shannon Stillwell. Peter Ortiz, big hello, saying hello to my fellow slimes. Hey to Peter Ortiz. I saw some boom emojis going on in the chat there. Anthony Samora says, I think Love has been pulled off the case. We ain't seen her in over a week. Smart move by the state. Unfortunately, I don't think that's the last we're seeing of her. I think her position is pretty cushy. So if she rears her head in this trial, I wouldn't be surprised, even if it's just walking into the courtroom to hand something over. But geez, can you imagine if she pops up and she's doing any of the cases for the severed co-defendants? We'll see on December 3rd with the status hearing for those remaining defendants. A whole mess. Thank you so much, Anthony. Angie Lay says, ladies in the court, do not make eye contact with Shannon unless you want to fall under his love spell. Happy birthday to Yak. You know what? All love to Yak today, right? Turn the attention to Yak. Happy birthday to Yak. Stay away from Shannon. If Kayla's still in here, she'll be like, yep, listen to Angie's advice. Sassy Experience says, what in the Handmaid's Tale is Paige's hair? You guys are so, like, I love that whenever there's a new thing in the courtroom, the chat is just all on it. The same day, like there was a day that there was a odd looking hand sanitizer bottle and we're all like, what? What is that? So the lint brush, the day the lint brush became a white lint brush instead of it used to be the orange one, we're all like, oh, a new lint brush. Just love it, love it, love it. Thank you so much, Sassy Experience. Good to see you. Squirrel Brain Gang is doing some stretching here, some incredible reaching, I think, is the picture here. Lots of reaching from Squirrel Brain Gang. My impression of a body telling judge about Kayla and Shannon. Acting like he was on an episode of Law and Order. Yeah, it was his ta-da moment. Got up there. I saw on X a few comments saying that it was like he was standing up in church like a gossiping lady. So, just a little messy. Chloe Alberts-Raven says, at least it's not a scrunchie. Carrie Bradshaw dumped a dude for even writing about a scrunchie. If you know, you know. That's true. And I'm surprised, you know, quick adjourning day here. Maybe she tied her hair back because she already knew she's going to be the one, like, writing this stuff out. But, you know, definitely knew it was going to be a different sort of day when she came in with her hair tied back. Let's also pull up. I think with opening statements, our best bet would again be Law and Crime because of the closed caption issue, but I think their sound was really, really loud back in the day. So let's figure that out. When we start doing opening statements, because I do think they were loud and blaring, I know a lot of people may have turned up their volume to hear court today. So we're going to have to take a moment before we toggle over to like everybody adjust their mic down. I mean, their volume down. And all right. Let's see. All right, 11 Alive. Let's see if they have closed captions. And else, okay, we'll do 11 Alive. All right, so does everybody, this is your call. You got a couple seconds here. Turn your volume down. I jumped the gun. I jumped the gun. But let's turn our volume down because I know the volume was different back then. And then I'm going to play it. And then if you guys give me the thumbs up or down to adjust my mic volume to now match what this is going to be, that would be great. So let's go. All right, so this is really loud. I'm going to up my mic. Going to up my mic. So now my mic is here. And this is how it would be.
How you doing?
Is this good? Is this good? What do you guys think of that? And I'll also cue it up here because we're going to skip love. Let's find JApp. I think JApp was earlier on. Wait, am I too loud? Oh my God, there's so much of Adrian Love. Okay, so Shart was first. All right, so we'll turn them down a little on the YouTube feed. And you guys let me know. What are we? About 7:06. YouTube's doing the thing. Why does it hate me? Why is it hating me? Oh, is that... Look at how full the room is.
Please be seated. All right, thank you, Sergeant Ingram. All right, does any member of the defense wish to make an opening statement this time?
Hold on. Look at him asking, and Shart is locked and loaded right here at the... he has to say that as a formality. But it's hilarious because he's clearly standing right here.
All right, Mr. Shart, you may proceed, sir.
Thank you, Your Honor. May it please the court. Good afternoon. Good afternoon. My name is Max Shaw. And along with my co-counsel, the gentleman with the white hair back there, his name is David Botts. And together we have the honor and privilege of representing Shannon Stillwell. Shannon Stillwell is an innocent man. He's been accused of the murder of Donovan Thomas in 2015. He is not guilty. He's been accused of a murder of Jamal Drinks in 2022. He is not guilty. He has been accused of conspiring to violate the Georgia State RICO law. He is not guilty. Now, I am going to deliver an opening statement that will preview
what I believe and what I believe the evidence will show in this case and the evidence that will come in trial. But before I even start previewing what I believe the evidence will be, I want to discuss with you some preliminary matters regarding this case. The first preliminary matter that I wish to discuss is my client's name. Okay? On the indictment, you will see, when you look at the indictment, that my client is listed as Shannon Stillwell, also known as SeaSoulJax. Okay, and there's a simple explanation for that. You will learn that his mother was a Stillwell, but he was raised by his paternal grandmother, Betty Jackson. So at times, he's been a Stillwell, at times he's been a Jackson. He's indicted as Shannon Stillwell. I know him as Shannon Stillwell, but throughout this trial, some people may say Shannon Jackson, some people may say Shannon Stillwell. I may slip up and say Shannon Jackson. But we're talking about the same person, Shannon Stillwell. Second preliminary matter. It has not been lost on me that my client, it's not lost on any of us, that my client is charged with 2 murders in this case. He's charged in 2015, and the evidence will show that he was wrongfully accused. And that case never went to court. He was accused in 2022, wrongfully, based largely on assumptions made about the 2015 case. We plead absolutely not guilty. With our backs straight and our eyes wide open, we plead not guilty to those charges. And finally, ladies and gentlemen, as far as preliminary matters, as you probably have realized through jury selection and the fact that we have some visitors from the press here today and different things about this case, this is somewhat of a unique case. It's drawn some attention. But the thing I want to stress is that this case is no different than any other case in the state of Georgia or the United States of America as far as criminal cases go. And it has the same ground rules as any other case tried in this great union. The ground rules of this case are that the defendant, Shannon Stillwell, and all the other defendants are presumed innocent. The state bears the burden of proving their case against all the accused individually. And the state's burden of proof is the highest burden in our system, beyond a reasonable doubt. Beyond a reasonable doubt. Okay, ladies and gentlemen, the state started talking in their opening about about colors and hand signs and different marketers and gang activity and all the rest. And I anticipate that the state will attempt to bring in colors and their belief about what colors mean in this case. Throughout this case, I'm going to ask you to focus on a couple colors as well, just to keep in mind as you hear the evidence. Okay, the first color is dollar bill green. Dollar bill green, as you may guess, is the exact shade of green that the U.S. government uses when printing U.S. currency. And the evidence in this case will show that many of these young men grew up without dollar bill green. The evidence will show, and you'll learn about different areas of Atlanta, Capitol Homes, Jonesboro South, places that have since been revitalized in some ways, but back 15 years ago were not nice places. Despair, lack of opportunity, poverty, lack of positive role models. You'll hear about Shannon and his upbringing. You'll hear that he grew up in the Forest Cove Apartments, which has since been condemned. And he was raised by his paternal grandmother, Betty Jackson. He couldn't live with his mother, who had succumbed to drug addiction, and it was his paternal grandmother, Betty Jackson, who raised him. And she raised him in the Forest Cove Apartments, and you'll hear that she loved him, poured love into him, called him her sweet thing, and he called her mom because she was mom. You'll hear that despite the love and guidance that Ms. Jackson tried to pour into Mr. Stillwell, at the age of 14, without other people providing him guidance, he dropped out of school. And he decided that he wanted to be a rapper. You'll learn about the rap industry in this case. And you'll learn, you probably already know this, but Becoming a rapper is not the same as signing up for a job at Home Depot, where you work for 2 weeks and you get your first paycheck. When you're chasing superstardom in the rap game, those paychecks might not come for a long time. And sadly, they may not come at all. They might be a dead end to nowhere. You'll learn about the vast numbers of young men with the same dream as Shannon and how the supply of potential rappers greatly exceeds the demand for superstar rappers. How it's really a bad occupation to try to get into when it really comes down to it. But Shannon was 14. And you'll hear how he tried to hone his skills and try to make it in the rap game. But you'll hear that Shannon, like many other young men chasing the same dream, weren't making any money. And bills have to be paid. And kids have to eat. And rent becomes due. In this case, and we're not going to hide from it, the chase of dollar bill green turned into a different shade of green for Shannon and many others. That type of green, that shade of green is called bud green, which is actually a color. You can paint your house bud green. But in this case, of course, bud green stands for marijuana. And you'll hear how Shannon, trying to make it in rap, sold marijuana. The state has alleged in their overt acts, okay? These are acts that they claim prove that there's some RICO conspiracy afoot. You'll hear that on August 23rd, 2013, Shannon was charged with possession of marijuana with intent to distribute approximately 1 ounce, over 10 years ago. And you'll hear that he pled guilty and did his time. You'll hear that in 2015, in July 2015, he was charged with possession of marijuana with intent and possession of a firearm. And you'll hear he pled guilty, took responsibility, did his time. You'll hear that in September 25th of 2019, he was arrested and charged with possession of a firearm. And he took responsibility and he did his time. We're not hiding from the fact that Shannon Stillwell has sold drugs. We're not hiding from the fact that he's been found in possession of marijuana. We're not hiding from the fact that he's been found in possession of a firearm, which is always synonymous with selling drugs. Okay. These are his path, his past, his truth, and they were his decisions. His motivation was to make money for him, to live, to pay rent, to eat. Ladies and gentlemen, we're not hiding from the past, but the evidence will show that Shannon's decisions, starting over 10 years ago, had nothing to do with YSL or any other organization. You won't hear evidence that Shannon was selling marijuana and then calling someone from YSL saying, hey, I got some money to support the organization, or calling Jeffrey Williams and saying, hey, I got some money for you, man. No, it was for him. He was a drug dealer. He pled guilty. He did his time. Just like thousands of other people in Atlanta. This has nothing to do with YSL. Has nothing to do with the January 10th shooting of Donovan Thomas. It has nothing to do with the 2022 shooting of Shimon Briggs. On count 1, on this indictment, the state charges Shannon Stillwell with conspiracy to violate the RICO Act. They say on or between January 24, 2013 and the 8th day of May 2022, he and others unlawfully conspired to acquire, maintain directly and indirectly an interest in and control of United States currency and other personal property through a pattern of racketeering. The state in their opening said, further the interests of YSL, further their goals. They also said they endeavored to do a lot of stuff to get them a lot of stuff. Okay, it's a little bit more complicated. And RICO, the actions need to be part of a racketeering organization, not a drug dealer selling drugs to put food on his own table before studio time to chase his dream as a rapper. I'm going to ask you, at the close of evidence, to find Shannon Stillwell not guilty. Count 1. Okay. The other color, besides dollar bill green, and I guess bud green, that I'd like to talk about is Fulton County blue. Now, Fulton County blue refers to the Fulton County Jail, 901 Rice Street, where people are taken when they're arrested for felony charges in Fulton County. And Fulton County Blue refers to the jumpsuits that these individuals wear, the county-issued jumpsuits that are typically navy blue, deep navy blue, and say Fulton County inmate on the back. You'll hear about the conditions of jail life and Fulton County jail life in particular, and common sense dictates some of this. You're confined to a cell, sometimes with another man sharing that small cell with you. You have no privacy. Use the bathroom in front of men, shower in front of men. You're in fear, danger. You're separated from your family and your loved ones. But most importantly, the men wearing blue, Fulton County blue, they've lost control of their lives. They've lost control of their destiny. Their destiny is now in the hands of the judicial system, in the hands of prosecutors. Ladies and gentlemen, Fulton County blue is going to be a very important color in this case, because the state's key witnesses in this case that they're going to call to testify, that I anticipate that they will call to testify against my client Shannon Stillwell, when they became involved in this case, they were all wearing Fulton County blue. When Darius Zachary, Kenneth Copeland, Sammy Davis, Jerron Stillwell, Spencer Wright will hear them testify if they're called. You'll hear what they've said previously, perhaps. But what you should keep in mind is, when did these men say what they have to say? Did they say it when they first got the information to share? Or when they claimed they first got the information to share? Or did they share it when they found themselves wearing the Fulton County blue? When they no longer had control of their destinies and they needed a favor? And they decided to insert themselves into a high-profile case that could solve all their problems. Okay. Let's talk about January 10, 2015. That's the case involving Mr. Thomas. And the evidence will show that this was a high-profile case. And the reason, this is not me talking. I anticipate the evidence will show. I anticipate the state's own witnesses, the state's own gang investigators will tell you, not me talking. I anticipate they will tell you that Donovan Thomas was a big deal, that he was a gang leader, that he was the leader of the Inglewood Family Bloods in Atlanta, that he was high-ranking. And that's what made this case a big deal on the streets. You'll also hear that this case, the shooting of Donovan Thomas, was caught on surveillance video. Now, I'm not going to suggest that it's the highest quality surveillance video, but it was caught on surveillance video. And you'll be able to watch the surveillance video. And you'll see McDaniel Street in downtown Atlanta at about 7:20 p.m. on January 10, 2015. Remember, winter, it's cold, dark. And you'll see a car zoom down McDaniel Street towards Northside Drive, headed northwest, I believe. And you'll see and you will hear testimony that Mr. Thomas was with other individuals. What they were doing, I don't know, but he was with other individuals in a parking lot in between two barbershops, one being Mr. George's barbershop and one being Mr. Bernard's barbershop. And you will hear that this car zoomed down this dark street on that January 9th, and it appears from the video that you will see that an individual starts shooting out of the sunroof in the direction of Donovan Thomas and others. And you'll see that surveillance video for what it is and what it isn't. And you will also see how quickly everything occurred that night, a matter of seconds. Detective Thorpe is the Atlanta Police Department detective that was assigned this case in January 2015, and you'll hear that he gathered the evidence from the crime scene. There was no DNA, there was no fingerprints of value. You'll hear that there were shell casings all along the street, but you won't ever hear that these shell casings were linked to any particular gun or Shannon Stillwell or anything else. And there were no eyewitnesses on January 10, 2015 coming forward saying, yes, I was here and this is what I saw. that I saw this person do this. There was none of that. And you'll hear that this case remained unsolved. No one had been charged for 9 months and 9 days. On October 19th, 2015, 9 months and 9 days after the Donovan Thomas shooting, a man named Nicholas Robinson was arrested on the streets of Atlanta and brought to Fulton County Jail for various pending charges. And you will hear evidence that Mr. Robinson decided he needed help. He didn't want to wear the Fulton County blue. You'll hear that he contacted Atlanta Police Department and got in touch with Detective Thorpe. And Detective Thorpe came out and interviewed this Nicholas Robinson. You'll hear what Nicholas Robinson said in this interview, how he gave his vantage point to Detective Thorpe, how Nicholas Robinson said that he was seated at the MARTA bus bench right across McDaniel Street from the barbershops. And you'll hear that Nicholas Robinson told Detective Thorpe that he saw it all, and he saw the people that were inside the car, and he gave names. Nicholas Robinson said, I saw Antonio Sledge. He came out of the sunroof shooting. I saw Kenneth Copeland. He was in the front passenger seat. I saw Tameka Garlington. He was the driver of this car. Quindarius Zachary, he wasn't there, but he supplied the gun to Antonio Sledge. And yes, I saw Shannon Stillwell, my client, in the back, passenger side, shooting a handler. So Detective Thorpe, after taking this information from Nicholas Robinson, who just broke the case, created photo lineups. And you'll learn what a photo lineup is. It's essentially 6 photos that contain a picture of a suspect, and then 5 what we call fillers. And you'll learn about that. And Detective Thorpe showed these photo lineups. A photo lineup with Antonio Sledge, and then a photo lineup with Kenneth Copeland. Each person had their own photo lineup just to ensure that Nicholas Robinson could pick these people out of a photo lineup. And Nicholas Robinson did. And he signed his name, Nicholas Robinson, next to the picture of Antonio Sledge, and next to the picture of Kenneth Copeland, and next to the picture of Tameka Garlington, and next to the picture of my client, Shannon Stillwell. Nicholas Robinson signed his name and said, these were the people in the car. Ladies and gentlemen, why am I telling you this? Well, Detective Thorpe had 2 small problems. First, you will see the surveillance video. You will be able to watch the surveillance video and the lighting conditions out there, and the fact that there's gunfire going every which way, and how fast the car is moving, and you will be able to judge, was it ever even believable that someone could see 4 people inside a car under those conditions? But there was a bigger problem that Detective Thorpe had. You see, you'll learn that during this interview with Nicholas Robinson, it wasn't only Detective Thorpe, there was another investigator there, an investigator Gaither. And while Detective Thorpe was talking to Nicholas Robinson, Detective Gaither was doing some investigation of her own and looking into Nicholas Robinson and who this guy was who had just been arrested. And after Nicholas Robinson picked out all these people, including my client, Detective Gaither had to tell Detective Thorpe a little secret. Detective Gaither had to tell Detective Thorpe, that guy in there who just signed those photo lineups that just signed our case, his name isn't really Nicholas Robinson. He lied to us about his name. His name is actually Spencer Wright. So, case was solved by someone who lied about their name. So, what was Detective Thorpe's solution? Well, this is what the evidence would show. Detective Thorpe completely overlooked the lie about the name. The improbability of a man spotting 4 different individuals in the car moving at a high rate of speed in the middle of the night. He overlooked those things. And he said to Nicholas Robinson, or said to Spencer Wright, I've come to learn that your name is not actually Nicholas Robinson, it's Spencer Wright. Could you look at these photo lineups again, and instead of writing a fake name Nicholas Robinson, could you actually sign your real name Spencer Wright? And Spencer Wright did. And what happened? Detective Thorpe, on October 19th, 2015, based on the word of Spencer Wright, the man who had just claimed to be Nicholas Robinson, Detective Thorpe took out warrants for Antonio Sledge, Tameka Garlington, Kenneth Copeland, and my client, Shannon Stillwell, based on what Spencer Wright said. Okay. Since October 19th of 2015, people have had an opportunity to review some things on this case. The surveillance video that you will see, it's interesting because not only does it show McDaniel Street, the catch the incident, but it also shows the Marta park bench right across from the barber shops on McDaniel Street. And know who's in the park bench? The bus Marta bench across from the barber shop? No one. It was all fabricated. It was all made up. It was all a lie. We've been able to review Spencer Wright's jail phone calls to associates made around that time. All but admitting, I'm lying. I need to get out of here. I'm inserting myself into a case so I can get favorable treatment, so that others get arrested. The state has since dismissed the charges against Antonio Sledge, Kenneth Copeland, and Tameka Garlington. They continue to push forward against Shannon Stillwell. Why is Spencer Wright so important? Why have I spent so much time talking about someone who clearly lied, who clearly wasn't there, who clearly made things up? Well, Spencer Wright gives us the blueprint. He tells us what to look out for. What was Spencer Wright wearing when he fabricated his story? Fulton County blue. What did he want? What was he in search of when he fabricated his story? Control of his destiny. He didn't want it to be left in the judicial system. He wanted to use something to get a deal. He wanted to take back control. That's what men in blue do. Okay. In this case, I anticipate the state will bring 4 witnesses forward. All 4 have certain things in common, as I stated. When they supposedly came upon information that was relevant, never shared it with law enforcement. But once they were wearing blue and they needed something, that's when they came up with their stories. I anticipate the state will call Quindarius Zachary, ironically, one of the people accused by Spencer Wright. You'll learn that he claims he knew information from January 10, 2015. January, February, March, April, May, never shared this information with anyone. But lo and behold, you'll hear he found himself in custody for serious charges on August 5th of 2015. Then all of a sudden he had a story to tell. You'll hear he gave a second statement to law enforcement approximately a year later, where he was in a room with the gang investigators, with prosecutors, including the prosecutors that were handling his case and had control over his destiny, his future, and his attorney. And you'll hear that he gave a second statement and was looking for a deal. Quindarius Zachary is no longer wearing blue. Quindarius Zachary is not charged in this case. He got his deal. You'll hear about Kenneth Copeland. Again, someone ironically accused by Spencer Wright. You'll hear that Kenneth Copeland hates jail more than anything. The problem is, for someone that hates jail more than anything, he does a horrible job of avoiding it. And you'll hear that throughout this investigation, he's repeatedly arrested by the Atlanta Police Department and other jurisdictions. And you'll hear 2 of those arrests were on June 10th of 2015 for guns, found in possession of guns. October 28, 2021, guns, found in possession of guns. And he makes it very clear about what he thinks about wearing the blue. But the interesting thing about him is, as you will hear, is every time he's arrested, law enforcement runs out to talk to him. And he goes through the same song and dance about how he'll do anything. Just don't, please don't make me wear that blue. Kenneth Copeland is no longer wearing blue. And he's not charged in this case. I anticipate you may hear from a man named Sammy Davis, who claims he was at the scene on January 10, 2015. January through December 2015, never once went to law enforcement. 2016, never once went to law enforcement. But then in March 17, 2017, when he's in jail wearing blue, law enforcement comes out and talks to him. You'll hear his story. His story about how 2 cars were driving down McDaniel Street, and the first car sent a signal to the second car saying, Donovan Thomas is just leaving the barber shop, as a signal that it's time to shoot. And how the second car pulled up in front of the barber shop and stopped in the middle of the street. Just stopped. And then people started shooting at Donovan Thomas. You'll hear Sammy Davis' story. You'll also see the video. You'll see that there's no first car, second car. You'll see that there's no signal. You'll see that Donovan Thomas wasn't just leaving the barbershop, that he had, in fact, like the state had already stated, been hanging out with friends in that parking lot for quite some time prior to the shooting. And most importantly, you'll hear, or you'll see on the video, that Sammy Davis's claims that his car stopped are 100% wrong. The car never stops. The car drives on by. Bullets flying everywhere. You'll be able to listen to Sammy Davis's story and compare it to the surveillance video to figure out how much value you should give his story. And finally, I anticipate you may hear from a man named Tremont Stillwell. A man who curiously claims he's my client's uncle. Not sure what that's about. You'll hear that he claimed to come across important information in January of 2015. And he claimed he came across this important information while talking to someone with his wife, Vanetta Duffy, right there. You'll hear throughout all of 2015, never said a word to law enforcement. Wasn't until March 22nd, 2016. Guess what color Tremont Stillwell was wearing at that time? You got it. When he was in jail for serious charges, and he needed help. He needed help from law enforcement to start to reclaim his destiny, control over his life, to escape the monotony and the filth of the Fulton County Jail. And you'll hear that he claimed to have information. You'll hear that the state, to their credit, went to try to corroborate whatever Tremont Stillwell was talking about and talked to his wife, who is now deceased. Her name is Vanetta Duffy. She's now deceased. But you'll hear that she was interviewed on May 11th of 2016 when she was still alive. And you'll hear what she had to say about Tremont Stillwell's claims. That what he's saying happened, never happened, A, and that Tremont Stillwell is a effing liar. Those are the state's witnesses in this case. Those are the men in blue. Count 2 of this indictment is the count that charges my client, Shannon Stillwell, along with a whole new group of individuals with the murder of Donovan Thomas. There'll be no forensic evidence, there'll be no ballistic evidence. There'll be no eyewitnesses that presented themselves at the scene to say, I saw this occur. The surveillance video will not give insight as to whether Shannon Stillwell was there or not. The state's case will rest entirely on the word of men in blue. When the evidence is done and trial is done in this case, I'm going to ask that you return a verdict of not guilty to count 2, murder. Okay. Hold on one second. Now, I would like to preview a little bit about my client's life after the Donovan Thomas murder. Remember, on October 19th, 2015, the Atlanta Police Department, Detective Thornton, and the news broadcast to the world, and more specifically to the streets, and more specifically to the Inglewood family blood gang that Donovan Thomas was the head of, that my client was responsible. Based on the word of Spencer Wright, based on the word of someone that even the state is saying lied. First they said it wasn't completely accurate, no, it was a lie. Based on that, they broadcast to everyone that my client was responsible. And there has been repercussions. You'll hear in 2015, People pulled up to my client as he stood outside his store, shot a gun at his head, and grazed his forehead. Thankfully, he's still with us. You'll hear that later in 2015, my client went to go get a fish dinner with the mother of his child and another young lady named Tiara Jones at JJ's Fish at the corner of University and Pryor. And members of the gang spotted them there, stalked that car, drove behind the car, and unleashed bullets upon that car, hitting that poor lady, the driver, Tiara Jones, in the face, killing her, causing the car to crash and spin, breaking bones in my client's body, collapsing his lungs. The streets have not cared that Spencer Wright is a liar. Since that time, my client's life has changed in some small ways and some big ways that I think make sense. Shannon Stillwell, since that time, has been careful about his surroundings. He tends to back into parking spots. He tends to run red lights at intersections, not to be a sitting duck for IFA members or anyone else. He habitually changes residences. And yes, he does habitually rent cars, including a white Audi. He does this, the evidence will show, so no one can associate him with any particular car. None of the IF gang members can know where he is. And yes, when he rents cars, he does tint their windows, so no one can see in. That's the life he leads since 2015. And yes, when he leaves the house late at night, he does conceal his identity. It was during COVID, but he does wear a mask. That's been Shannon Stillwell's life since 2015. And I'm going to ask that you keep that into account as you consider the evidence as it's presented. Now, 7 years later, March 14, 2022, remember, Shannon has been publicly accused, but no one has ever taken that case to court. No one has ever even tried to actually prove the case. They just accused the case. And Shannon has remained a wanted man. Not by the police, but by someone scary. On March 14, 2022, the evidence will show that Shannon, Marvius Nichols, Nikion Garlington, and Miles Farley were planning on going to the music studio to work on music. Still chasing it. The evidence will show that Mr. Garlington was a passenger in Mr. Stillwell's and Shannon's rented white Audi with tinted windows. And Mr. Nichols was with Mr. Farley in Mr. Nichols' white Ford Fusion. The evidence, and you'll see, in this case, you'll see there's several different surveillance videos that you'll see in this case. The first being the BP footage. That's from the BP at the corner of Fulton Street and Windsor Street in Atlanta. And you'll see the video. And you'll see Mr. Stillwell. No, we will never deny that he was at the BP. We will never deny that. We'll never deny that he was in a rented white Audi. And you'll see Mr. Stillwell pull up on that camera and back into a parking spot right in front of the BP. And you will see Mr. Nichols shortly thereafter in his white Ford Fusion pull up at the gas tank so he can purchase gas to get to the studio. You'll see footage from inside of the store. That's Mr. Nichols. You'll find out that that's Mr. Nichols purchasing an item, and that's Mr. Stillwell, my client, wearing a Pink Floyd hoodie with a pink wool cap on. And you'll be able to observe them on video, and you'll see Miles Farley, a third person in their group, a shorter individual, come in, and you'll see them playing around and pushing each other in a playful manner as friends do. I'm going to ask you to observe them on the video and ask yourself, does that appear to be men on a mission? Or does it appear to be friends just planning on going to the studio? The video will reveal that at some point, a gentleman by the name of Shamal Drinks pulls up in a red car at another, in fact, I believe that's a picture of it right there at that gas pump, and he enters the store. You'll be able to see the video of him entering the store from the parking lot, and you'll be able to see him inside the store. you'll see that he gets into some sort of argument or altercation, not an altercation, an argument. It appears with the clerk, and he leaves the store, and he gets in his car. There will be no interaction whatsoever between Mr. Drinks and my client, Mr. Drinks and Mr. Farley, Mr. Drinks and Mr. Nichols, Mr. Drinks and Mr. Garlington. There'll be no interaction at all. And you will see Mr. Drinks exit that parking lot and take a right on Windsor Street. And then you will see Mr. Stillwell exit that parking lot and take a right on Windsor Street. And then you'll see Mr. Nichols exit the parking lot and take a right on Windsor Street. And that's where the FedEx surveillance footage will take over. And you'll be able to watch the FedEx footage on Windsor Street, which will show these cars drive up and end up at a red light. You will see my client's car, white Audi, run a red light. You will see Mr. Nichols follow my client's car and run a red light. Eventually, cars come in to replace him, and traffic flow continues and continues for several minutes. And eventually, a man who's just happened to be going the other way looks into Mr. Drinks' car, which is still sitting there, and notices that Mr. Drinks has been shot. What you will not see on this video is any indication at all that this shooting occurred while my client's car was beside Mr. Drinks. You will not see any muzzle flash, you will not see any commotion, you will not see any fight, you will not see anything at all that suggests that that's when the shooting occurred. So this March 14, 2022 case, what I anticipate is you will not hear any eyewitnesses say that Shannon Stillwell, and let's be clear, the state is accusing Shannon Stillwell. I mentioned that there's 4 people in this party. They are accusing Shannon Stillwell of shooting Mr. Drinks out of that white Audi. The state will not present to you any witnesses that saw this occur. The state will not present to you any forensic evidence that proves that this occurred. The surveillance I submit to you, and you'll be able to see and judge for yourself, points to the exact opposite, that the shots did not come from Mr. Stillwell's car, nor did, and I'm not suggesting they came from Mr. Nichols either, they came from neither car. So why was Shannon Stillwell arrested? Well, they had video of Shannon at the BP. Okay, that's fine, we don't deny that, never will. They made certain assumptions about what would be on that FedEx video that you will be able to look at and determine what it shows and what it doesn't show. And I'm sure they assumed that it would show some shooting, but it doesn't. And finally, they made assumptions about Shannon Stillwell. Remember what the state said in opening about how Detective Hogan had his case. He had people on a video at the BP, which is near where the shooting occurred, but not where the shooting occurred. He had people on his video, and then he talked to another detective, Viverito, and Viverito said, "Oh, that's Shannon Stillwell. That's Shannon Stillwell. Oh, that's Marcus Nichols." And they just ran with it. Yeah. Shannon Stillwell was at the BP that night. He didn't shoot Jamal Drinks. None of his friends shot Jamal Drinks. They went to the studio. Since these warrants were taken out for Shannon Stillwell, and I'll tell you the warrants were taken out and Shannon Stillwell was arrested in that same white Audi on March 17, 2022, 3 days later. Since those warrants have been taken out, some other information has come forward. First, I'm going to ask you, and this will be entered into evidence, I'm going to ask that you consider the rental agreement for the white Audi. You will learn that on March 16, 2 days after this alleged shooting, when every other person who has a guilty conscience, anyone who has a guilty conscience is trying to get out of the rental car, Shannon extended his lease. I'm going to ask you to consider and really think about that. Extending a lease of a car that you supposedly just killed someone. Are those the actions of someone who's guilty of that crime? You're going to hear about the wiretap on Tameka Garlington's phone. Remember, Tameka Garlington was in Mr. Stillwell's car. And the state hinted at it a little bit. They were talking about Jay Myrick and people wanting to attack a man named Lucci. And based on these concerns in the jail, The state applied for it, and you'll learn what a wiretap is. They applied for a wiretap and received a wiretap for Tameka Garlington's phone. The phone of the person who was with Shannon Stillwell on March 14, 2022. And you'll learn what a wiretap is and how a wiretap really consists of law enforcement sitting and listening in on all your phone calls, incoming and outgoing, and recording all the relevant and pertinent phone calls and conversations that occur. You'll learn that this wiretap on Tameka Garlington's phone began on March 10th, but certainly well before March 14th, the date of the Shamal drink shoot. So it was in place that night. Who knows about the wiretap? You'll learn that too. Do you think the government tells you that your phone is being wiretapped? Of course they don't. It's secret. No one knows. That's the point. And you'll learn about who Tameka Garlington is and what type of guy he is. I would submit, if you have a secret, you wouldn't want to tell Tameka Garlington. You'll hear about the wiretap drunk, high, talking about everything under the sun, pills, weed, guns, girls, robberies, all stuff that he's involved in, completely against his interests to discuss, but he doesn't know he's being listened to now. But one thing that's interesting, of all the things that this loudmouth talks about, all the crimes, and they said they bragged about this stuff. They said Tameka Garlington was bragging about this stuff. All the things they brag about, no, it never comes up. Shooting anyone on March 14, 2022. All the crimes he discusses, that never comes up. Finally, and most importantly, the science about this March 14, 2022 case. We're going to learn about gunshot residue. Gunshot residue testing that tests for microscopic particles that contain a combination of lead, barium, and antimony. Particles that come from the explosion of a gun in the gunshot primer that causes it. Synonymous with a firearm that has been fired. Who does gunshot residue testing? Georgia Bureau of Investigation, APD, all sorts of agencies to build cases against defendants. You'll learn how gunshot residue is collected. How you take a surface or a body part or an object, and you take these adhesive stubs, these official gunshot residue kits, and you dab the surface of an item as much as you want. You can use multiple stubs. And then you take these stubs and you place them under an electron microscope. And a scientist can look under this microscope and see if there's any particles of gunshot residue that are on said item. You'll hear that Shannon Stillwell was arrested on March 17th in that same white Audi that he was in on the 14th. And you will hear that the crime scene technicians, in this case, made a specific decision to pick the best place on a car to test for gunshot residue. When the gun is fired, the gunshot residue would plume upwards. And so they take the best part of the car, the headliner. And for all of you that don't know what the headliner is, that's the cloth top of the car. That's pictured right there. You'll hear about Alexander Coven, a scientist, a man in search of the truth, a man who works for GBI, not for me, not for Shannon Stillwell. And you'll hear how that headliner that was collected from that white Audi on March 17th was brought to Alexander Coven at the Georgia Bureau of Investigation. You'll hear he's an expert in gunshot residue collection and analysis and detection. And you'll hear how Mr. Coven, as he was trained, took that gunshot residue kit, and took those adhesive tabs and dabbed that headliner again and again and again and again and again and again, dozens of times. And then he wanted to make sure what he did was sufficient, so he took a second tab, adhesive tab, a fresh one, and continued to dab that headliner again and again and again and again and again to pick up any particles that would be on the headliner from that white Audi. And he took those tabs, those adhesive tabs, and put them under his microscope that he uses when he's building cases for the state. And he looked at those tabs under that microscope for any particle of gunshot residue, any at all. From 15, 10, 5, 3, 1, whatever he could see. And you'll hear that on June 3rd, 2022, 77 days after the state, after Detective Hogan, Investigator Viverito, and the state made their decision that Shannon Jackson fired a gun, Shannon Stillwell fired a gun from that white Audi. 77 days after they made that decision, you'll hear that scientist Coven released his report. And on that headliner, there was not a single, zero gunshot residue to be found. That's the science. Ladies and gentlemen, regarding the March 14, 2022 case, the state has made 5 charges, 5 different counts against Shannon Stillwell, my client. First is count 49 on this indictment. It is murder, alleging that he shot out of the white Audi, and shot Jamal Drinks. The science belies those accusations. I'm going to ask you to find Shannon Stillwell not guilty of that count. Now, count 50 and 51 deal with violations of the Criminal Street Gang Activity Act, and they are essentially charges that say that Mr. Stillwell committed murder to further the interests of YSL, and he committed murder on behalf of YSL for the purposes of increasing his standing within the gang. Y'all are smart people. Obviously, I don't need to say it, but it'll make me feel better if I say it. If he's not guilty of count 49 murder, he cannot be guilty of count 50, and he cannot be guilty of count 51. Counts 52 and 54 similarly charge Shannon Stillwell with possession of a firearm by a convicted felon on March 14th of 2022 on the belief that he used a firearm to kill Jamal Drinks. If the state does not prove that case beyond a reasonable doubt, he cannot be found guilty of count 52. And count 54 charges Shannon Stillwell with possession of a firearm during the commission of a felony, that felony being murder. Obviously, if he didn't commit the murder, then he cannot be in possession of a firearm during the commission of said felony. In conclusion, my client has been charged with 2 separate murders. He's been wrongfully accused of 2 separate murders, and we plead absolutely not guilty. He's been charged with conspiracy to violate the RICO Act. And while now, he has sold marijuana in the past. Those were his decisions, for his benefit, and had nothing to do with YSL or anyone else involved in this case. He's pled guilty to those charges. He's done his time. That makes him an ex-drug dealer. It doesn't make him a conspirator. It doesn't make him guilty of violating any RICO acts. The ground rules. Shannon Stillwell is presumed innocent. The state bears the burden of proof, and the standard of proof is beyond a reasonable doubt. I believe in this case, if you focus on where the state's evidence comes from, you will find that primarily it comes from the stories of men wearing blue. I'm going to ask you to focus on things like science instead of stories. Compare the credibility of a scientist like GBI scientist Coven, who followed all the rules and determined there was absolutely 0 gunshot residue in that outfit. Compare that to what the state presents. Spencer Wright, who said his name was Nicholas Robinson, who lied, get out of jail. Spencer Wright duped Detective Thorpe on October 19th of 2015, and that is on Detective Thorpe. I am going to do my best to make sure that the truth comes out in this case. Make sure that no one wearing blue will be able to dupe anyone during this trial. My client, Shannon Stillwell, is not guilty. Thank you very much.
Now, what's interesting there is he really found a way to lay out like the shadiness of how this case, the information for it's coming together, but he didn't have to toss shade directly at the state. It's indirect because the state's relying on people where there's clear credibility issues, right? So you can read between the lines and still get that shade, but it makes his opening statement come off as like extremely genuine, right? And he ends, my goal is to uncover the truth, right? And I think after his opening statement, I don't really think the jury had a reason like, oh, he's going to be grimy throughout this trial. Don't think he's going to be grimy. So this was the first day on a date, and that was the end. So you can see like put this down for a second. You can see like there's not much left. They just close out court for the day here. And then on day 2, we get more opening statements from other defense attorneys. We're going to watch Jay Apt, who is for Diamante Kendrick. So we're not going to cover the other co-defendants. We're going to look at Diamante Kendrick because he's the other remaining co-defendant here. I do want to give a big thank you here. Allie B from Tennessee, thanks for the 5, saying, Kat, you are our queen slime. You know, I don't want to take the title, but happy to host. Happy to host, and glad you are here, and thank you for the compliment. Harp City says, Burrito, YouTube said he wants to rule the world. Oh, Young Thug. Young Thug said he wants to rule the world, Judge. We have to tap his phone, Judge. Oh, I love this song. Everybody wants to rule the world. The Tears for Fears. Good one. That's a good throwback there. But that's really... Vivarito's just a mess. Vivarito is just a whole mess. And I really hope that she, like, Googles her name, looks on Twitter, and feels insulted, and maybe does some self-reflection. Like, I don't think there's a reason to spare her feelings. I just don't. And I don't say that often, but it is what it is. And great recall here. Love this song. Chloe Albert's Revenge says, so Hilton opted for a simple piece from her funeral dress selection. Yes, so this morning in court, the state's table looked like they were in mourning with the colors they were wearing. And Chloe says she's watching the stream. Yeah, I think if you watch the stream, you'll see several people say they think the case is dead for the state. I think, you know, again, don't always be too optimistic. Juries are unpredictable and RICO is very broad. But either way, this case is a whole mess. I think if they're convicted, I think there's still going to be something unfair about it. A whole mess. So, Hannah P, thanks for being a member. Here to watch the state fail again today. Yep, they didn't really get much done. They did not get much done. And now they've got to sort through what evidence is going back to the jury. And what's a mess about that is we've seen the state mess this up a few times, right? The issue of things, you know, we can talk about it, but we can't publish it to the jury. And they mislabel things. And I feel like this is going to be a mess to sort out where these defense attorneys need to be on their toes. So it's a pretty big day, even though court is adjourned for these attorneys. Chloe Albert's Revenge out here sniping. Thank you so much, Chloe. Hannibal the Conqueror. It's our 1-month anniversary. We're official cat. All right. We've known each other longer. We've known each other longer out here on YouTube. But thanks for being here for a month. Ike is also out here sniping. You guys like posted around the chat, like looking for people to slime. You and Chloe like making marks together over walkie-talkie. Love it. Sea Travel says time to start planning for the next Fulton Rico trial. I mean, is that going to be like Cop City, maybe? I don't know the scheduling dates for things that are going on. But, you know, we'll get together. We'll get together and talk about it. Thank you so much for being a member for 3 months, by the way. Chloe Albert's Revenge says Abate is regretting that last haircut. He wanted that ribbon for himself. Oh, you guys be going at Abate's head. Oh, man. Chloe also says, I heard Abate is taking Hilton's broom shopping after court today, hence the dress and then the Bellinis. Chloe, I never want to be on your... I don't think it's being on someone's bad side, but I never want to be in your crosshairs for your targeting. Holy moly, you go bananas. Laura Rodzavala says, maybe a stupid question. If the jury comes back the same day with a not guilty verdict, can the state challenge that? Do you think the jury will watch trial to see what they missed? P.S. It's totally my birthday. Okay, happy birthday to Laura Rodzavala. Also, I think the D's Life Jenny, She said it's her son Mason's birthday. So we've got 2 birthdays here in the chat. So big happy birthday here to Laura and to Mason. But here's the deal. The state can try to raise an issue, but the court and the parties are supposed to assume, unless they have a reason to believe and can probably show otherwise, that there was something bad going on, juror misbehaving. Like maybe a deputy says that a juror was on the phone talking to someone and said, okay, I'm going to change my decision based on what you just told me over the phone. And that gets back to the court. Like there would have to be a reason for them to challenge. I'm not going to say that the state won't try to say that there's a juror issue if they come back that quickly. But I think it'll fall flat unless, again, there's really tangible proof that somebody did something that they weren't supposed to do. But the jury gets the benefit of the doubt that they're following the instructions. And even though you're not supposed to tell the jury about jury nullification, if they do that, that's something that they can do. So it's not a stupid question. And it would not be surprising to see someone raise an issue after a verdict like, hey, we think one of the jurors, something was wrong with one of the juror. But at the same time, they're just not supposed to. They're really, you're supposed to put faith that they're doing what they're supposed to do, which is a big part of why jury instructions and verdict forms are so important, even though it's boring. So, Gina Samino says not guilty on all. State didn't prove it. Please take a poll. This is a little late, but we can do a poll. My bad. Throw one up here. And I'm going to keep it simple with 3 options. Guilty, not guilty. Well, I guess 4. We'll have to do a hung jury. And then, like, compromise verdict. All right, so that should be up there for you guys. Good idea. Sorry I'm late on it, Gina. Pam, Todd, thank you so much for the super sticker here with the rocker hands. Appreciate it. KC Dog says Max told them in his opening statements the state's own witness would back his case. Yep. Their pride wouldn't let them take heed, and here we are 1 year later. Right, they were willing to threaten someone with contempt and hold them in jail until the end of this trial, which would have, even if it was as short as it is now, would have been until at least now, like Thanksgiving time. That was back in June. So they were willing to threaten that with somebody to get them to get on the stand, even though what was the result of it? You wanted it so badly that you wanted to hold a jail sentence over someone's head for contempt. Just to get a hot mess for yourself, for your whole case. Just down bad this whole time. So, and oops, sucks for them. Sucks for them. Ike says, don't forget we predict breaks because Paige is Diet Coke. You know, well, so that's the thing, right? We're going to have breaks during closing and opening statements too, right? So this 5.5 thing, they'll probably, can you imagine if they don't take a break and they just make them sit there for the 5 hours and get through it? Me, I'm the type of person I'd want to just do it, like get it done with. But I know not everybody's like that. But just 5 hours of torture. Oh, gosh. Yeah, and I might, we need some popcorn that day, Ike. We need some popcorn for sure. Black Butterfly says, Max delivered all he told them. Did the state? Nope. And I agree. Max really has known this case like the back of his hand. And the other attorneys on this case, they've done their work too, but they have given specific compliments and flowers to Max Shart for the way he knows this case like the back of his hand. They even say he knows everything that's in a video, everything that's in these calls. So really, 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 like, great attorney, passionate attorney, well worth every penny. And I wish everybody could have an advocate like Max. So, but yeah, you're absolutely right here, Black Butterfly. Good to see you. Hope you're doing well. Mrs. R says, slime, slat, free the guys. Heck yeah. Violet says, every young person in the street should watch this trial. If this trial doesn't scare them straight, nothing will. And I really do think this is valid, right? I am all for protecting free speech, but at the same time, just because I think that should be a protection, I don't think we should be infringing on that. You know, sometimes you want to avoid, like, this might be a battle you want to pick. If something could be used against you, maybe it's worth it to just say, I'm just not going to say that. And it's just the unfortunate reality. So Violet, this is a good point. You know, maybe showing off or doing whatever your reason is for putting certain things on social media at the time. Maybe reconsider the long run if that could be used against you. And that really sucks. That really sucks. KC Dog says, Max said science versus stories. That's slippery. Well, true, but I think right after he said it, he went right into that gunshot residue and then was banging on the table. And in my opinion, when you have something like sensory going on, it calls your attention in the moment. You also have that to remember by. I think it makes it stand out more. So I think part of his planning was strategically, I'm going to say this, I'm going to bang on the table, and that's going to be memorable. And when I'm banging on the table, I'm going to be talking about this gunshot residue. And he beefed up. He was like, they did the greatest work. They went to the exact best spot in the car where you would find gunshot residue. Goes up. They went and got that headliner down. They tested it. And they didn't find anything. Like, I think that was masterful, the way he planned that out. And it matches this whole case, right? It's not just I wrote a really good opening and then my case doesn't match it at all. So I do get what you're saying here. It can be a slippery slope. Because science can change, right? What we think is, established science, that can change. So, like dental matching used to be used in trials and now it's junk science. So this is true. And I think we got it all. So we can get caught up here. We're going to watch J Apt. I think. Make sure we're not missing like his first sentence. And captions. There we go.
It is more important that innocence be protected than it is that guilt be punished. For guilt and crimes are so frequent in this world. That's a quote from the man who wrote into our Constitution what the presumption of innocence means. His name was John Adams. He was the second president of the United States, right after George Washington. Why is that quote important? Why is the presumption of innocence important? Why did that get included in our great Constitution? Because we want to make sure that we don't accidentally send innocent people to prison. Innocent people don't get punished. I have the great honor of representing Diamante Kendrick, who's sitting in the gray vest at council table with me, along with my co-counsel, Doug Weinstein. Doug, stand up so everyone can see you. Also, you'll meet or hear from, at times, Katie Hingerty. She was here yesterday. She was the tall woman, blonde hair. And the three of us have the great honor and privilege of defending Mr. Kendrick. I've been practicing law here in Atlanta for almost 30 years, exclusively representing innocent people like Mr. Kendrick. He is not guilty. He is not guilty of every accusation and every count in the indictment that the state alleges. Let me say it a third time, just so you're clear. He is not guilty of every single charge against him. He is presumed innocent, as our great Constitution demands. And we won't have to prove anything to you, as the judge told you. The burden will always lie on the state, and boy, is it a high burden, beyond reasonable doubt. Now, it's not a mathematical certainty. The Judge Granville, is a great judge, by the way, and very smart, and knows the law really well. He will instruct you as to all the law. None of the lawyers will. But that beyond a reasonable doubt standard is a tough standard for them to meet. And the evidence in this case against my client is so very weak.
And this is so beautiful. I'm not going to pause a lot here, but this is so beautiful because what just happened with some of the charges against Diamante Kendrick? We got a directed verdict. Whew.
The state's not going to be able to come anywhere near the standard required. My client, Mr. Kendrick, grew up here in Atlanta in a tough neighborhood. He did not come from money. He was poor, hungry, deprived, socioeconomically disadvantaged. But he had a loving mother, a mother who's been with him the entire time of this case and will be every day. And she made sure that he had the best upbringing that he could. You heard Mr. Steele earlier talk about the disadvantage of how Mr. Williams was brought up, and my client had a similar upbringing. It was tough. Food, clothing were sparse. But he dreamt of a better life for himself and for his family. And through hard work, through creativity, maybe a little luck and fortitude, he became a very successful musical artist, a rapper. Now, despite Mr. Kendrick's mom's best efforts, he did get into some trouble. And we acknowledge that. We don't hide from it. We don't skirt it. Mr. Kendrick, you'll find out, went to prison between 2015 and 2020. So, the state is actually limited because during those years, he's locked up. He can't possibly be committing any crimes they've alleged. You'll also hear that he pled guilty to a crime right here in Fulton County in 2017 while he was locked up. And he admits that wrongdoing. He owns it. He paid his debt to society. But he also worked hard and obtained success in the music industry. And not just for fame or money. Mr. Kendrick did it because he wanted to give back to his community, a community that was disadvantaged. And that's exactly what he did when he got successful. He did tremendous civic duty. You'll hear evidence that he volunteered, he helped coach a youth football team, and he gave back to his community. He gave back because he knew it was the right thing to do. Now the state, and the evidence will show, the state, the police, and the prosecution want to use Mr. Kendrick's past. They put it in the indictment. Despite having paid his debt to society, the state is going to use his prior conviction to try to bootstrap these old crimes that he's already paid his debt for to get you, to convince you that he's guilty of these new offenses. They're going to try to get a second bite of the apple, despite the fact that he served his time, that he pled guilty. They want you to find him guilty again because of a debt he's already paid. And that's not right. They can't prove, using actual evidence in this case, the new crimes that they're alleging in the indictment, so they have to get you to pay attention to the old past he left behind. The evidence will show that he is not guilty of the charges in the indictment, and that the police and the prosecution's case is so incredibly weak. But they have to distract you with the old Mr. Kendrick, the Mr. Kendrick that paid his debt and pled guilty and served his time. It's like a bad magic trick. You ever see a bad magician who's like, look over here, while they're picking your pocket. That's the evidence the state wants you to pay attention to. I've been involved in a lot of RICO and murder cases in my career, in almost 30 years of doing this job. But the judge told you, and the prosecution told you, this case is unique, different. Why? It's going to take months. There are going to be hundreds of witnesses. It is massive. It's definitely the biggest case that any of us have ever been in. Maybe the biggest case in the history of the state of Georgia. Why is that? Lots of murder cases, gang cases, RICO cases take 1, 2, maybe 3 weeks to try at most. Why is this case going to take months? I'll tell you why. Because the evidence will show the government has got to drag in hundreds of witnesses to dance around the weak actual case that they have. They've got to bring in 5 experts to tell you what a gang is. They've got to bring in an expert to tell you what an Infinity is, an Infinity automobile. They've got to bring in dozens and dozens of witnesses that are not going to say, Mr. Kendrick committed a murder. Mr. Kendrick possessed or sold drugs. Mr. Kendrick possessed illegal firearms. They're going to tell you everything under the sun that dances around the facts and hope that after hundreds and hundreds of witnesses, you're either so confused or so worn down that you'll believe the state's theory. If the case were direct and the evidence were true, it wouldn't take long to try, because they bring to court someone to say, I saw Mr. Kendrick kill Donovan Thomas. They don't have that. And we're going to talk about what else they don't have, but they don't have enough evidence to prove my client guilty of any of these charges. And so to put lipstick on a pig, they've got to try and bury you with hundreds of witnesses that won't tell you that my client's guilty beyond reasonable doubt. Why not bring in someone to say, Mr. Kendrick's fingerprints were on a firearm. Mr. Kendrick's fingerprints were on a bag of drugs. Mr. Kendrick's fingerprints were in the Infinity that was used to kill Donovan Thomas. Mr. Kendrick's DNA was present at the scene of the crime. Why not bring in one witness out of the hundreds that you're going to hear from that will just say, I saw Mr. Kendrick do it? Why not? Because it doesn't exist. And our Constitution and our set of laws and our democracy demand more. They demand that high standard. You may not like Mr. Kendrick or any of these other defendants, but we are not here for a popularity contest. We are here to decide something so much more important. And the state doesn't have the evidence to do it. The evidence doesn't exist, not real concrete evidence. The evidence will show that the state is trying to find Mr. Kendrick guilty by association. That's what they want you to believe. Because they want you to find him guilty because who his friends are. The evidence will show that he had friends, that he knew people, that he associated with people. I thought in America, we had freedom of speech, freedom of association in the First Amendment. But the state wants to present evidence to show you that those freedoms are not true, that the Constitution does not matter. They want to present evidence that Mr. Kendrick is guilty by who he hangs out with, the color of the clothes that he wears, the symbols he makes with his hands, and the beautiful lyrics that he writes and sings. Those aren't actual crimes, that's just free speech. And that is what is on trial here, the First Amendment of the Constitution. They want you to look at evidence and say, these people are guilty because they exercise their right to free speech in America. That's not just wrong, it's un-American. Now, the evidence will show you in 2020 that when my client did get out of prison, due to his hard work, his talent, he became a famous rap star. Almost like buying lottery. You know, the chances of a young person going in the music industry and making it are very, very small. But that man was successful. He used his brain, his creativity, and his really hard work to make his family and his mother proud. And the government wants to punish him for that success. They told you in their opening argument to find him guilty because of overt acts. And they had the gall to tell you that those acts didn't even need to be crimes. Judge, that's what the evidence will show. That's what the state says the evidence will show. They told you that those overt acts don't even have to be crimes, but you should, as a result, find him guilty of criminal RICO. This isn't a civil trial, this is a criminal trial. And they told you he doesn't even need to commit a crime, but you should find him guilty of a crime. Does that make sense to you? Does 1 + 1 equal 3?
I stand in objections to that. Ladies and gentlemen, disregard counsel's last remark.
What are the charges against? Thank you. What are the charges against Mr. Kendrick? The first and the biggest is a murder. We've heard a lot about the murder of Donovan Thomas already. Now, Donovan Thomas is not, and it's tragic, and murder is wrong. The state had the nerve to show you an autopsy photo in opening argument, not because they needed to prove that Donovan Thomas died, but to exaggerate and scare. The evidence will clearly show that Donovan Thomas died. We concede that, and it's a tragic occurrence. And my client and his family agree for the family of Mr. Thomas. We don't think it was acceptable. But my client had nothing to do with that man's death. He died because of a drive-by shooting at a barbershop on January 10th, 2015. And what happens next? The police arrest the wrong group of people. They admit they arrested the wrong group of people. You heard Mr. Sharp and Mr. Steele tell you about Kenneth Copeland and Tameka Garlington and the others who were arrested for this crime. And the police charged them. And what is the evidence that turned out that those people got their charges dismissed and Mr. Kendrick got charged instead? Are there fingerprints of Mr. Kendrick on anywhere at the crime scene, on the body of Mr. Donovan, in the car that was used, on a firearm that was used? Are there fingerprints anywhere that tie my client to that crime? No. What about DNA? Is my client's DNA anywhere related to the death of Donovan Thomas? No. What about ballistics? Are you going to hear evidence that there was a match between the bullets or the gun used to kill Donovan Thomas that was a gun ever possessed by Diamante Kendrick? No. Are you going to hear from a single witness out of the hundreds of witnesses that are going to be brought here by the state? One. I beg you for one witness to come to court and stand right here on this witness stand and say to you, I saw Diamante Kendrick kill Donovan Thomas. Will that occur? And the answer is resoundingly no, because my client is not guilty, ladies and gentlemen. He's an innocent man wrongfully accused of a murder he didn't commit. And if that doesn't get you upset, I don't know what will. It makes me angry. Not one witness. There's videotape that the state will present of an infinity automobile driving by the barber shop and being used to kill Donovan Thomas. Are you going to hear witnesses that say my client owned the Infinity, rented the Infinity, leased the Infinity, was the rightful driver of the Infinity? Nope. Will you hear or see evidence to the contrary? Oh, yes, you will. Shortly before Donovan Thomas dies, the state has another video of my client getting into, are you ready? A Pontiac Bonneville. Not an Infinity, a Pontiac Bonneville.
Why does it seem like he's shading Pontiac?
So, will you see evidence? Will the evidence show that my client is Superman and can fly through the sky from one car to another? No, you will not. He is not Superman. Maybe he's Mr. Spock and he can teleport. You will not hear evidence of his ability to teleport from one car to another either. And yet, the state claims he's guilty of murder. Now remember, you heard previously about a man named Nicholas Robinson, whose real name is Spencer Wright. He came in and told the police, and they made arrests of Mr. Copeland, Mr. Garlington, and others. The state's key witnesses. But you've also heard evidence that Mr. Copeland is a terrible liar and a terrible person, and himself a gang member, not to be trusted and not to be believed. But that's the state's key witness who says, oh yeah, it wasn't me, it was Mr. Kendrick and others. Why do we know he's lying? Not just because his lips are moving, but because he was one of the people who was originally charged with the murder. How naive does the state have to think you are to not understand that the incentive for Mr. Copeland to lie is as simple as, I'm charged with the murder. If I say someone else did it, then I don't get charged with the murder. It's a ridiculous theory that they have, quite frankly. And the evidence is so super thin and super weak, it reminds me of nothing more than a Krispy Kreme donut. Thin air. In fact, Mr. Garlington, when he's interviewed by the police, says, yeah, I don't know who killed Donovan Thomas. They have no way to corroborate it. They have no actual evidence. The state wants you to buy into this theory of murder, and our Constitution demands you don't. It charged a bunch of people, the police, the Atlanta Police Department, figured out, oh, we messed up and got it wrong, but now we're going to charge a bunch of other people. But trust us this time. Does that imbue trust to you? Is that evidence that you'll hear about that seems trustworthy? No, it is not. That evidence is completely untrustworthy and unbelievable and unreliable. It's a bad magic trick. No fingerprints, no DNA, no witnesses, no ballistics, and videotape that actually exonerates him and proves that he's not guilty. Krispy Kreme donut hole. What's the next charge against my client? Well, there's a bunch of them involving guns. And 3, to be exact. One is that he's charged with possession of firearm during the commission of a felony. If you're committing some other felony and you're using a gun, you get charged as an extra charge. The second is possession of a machine gun. Ms. Love described to you, Mr. Steele described to you what a fully automatic weapon is. Pull the trigger once, all the bullets fly. That's illegal. And the third is possession of firearm by a convicted felon. Yes, Mr. Kendrick's a convicted felon. So he's not allowed to possess a gun. And he knows that. And again, the indictment. We've talked a lot about the indictment. You're going to get it. It's a document. It's a long document. But the indictment charges my client with those 3 firearm charges, all stemming from one date, March 9th of 2022, the date that Mr. Kendrick is arrested. So what happens on March 9th of 2022? He's at a house owned by Jeffrey Williams, his friend and colleague, who he's made beautiful music with, wonderful music that's entertained millions of people. And at that house, the police, and there's dozens and dozens of people at this house on the night of March 9th of 2022. It's not like there's 2 or 3 people there. Dozens. And there are guns in the house. So, how do we get to firearms being in the house to Mr. Kendrick possessing firearms? We don't. We don't. There's not going to be a single piece of evidence showing that Mr. Kendrick's fingerprints are on any of the guns. There's not going to be a single piece of evidence showing his DNA is on the guns, and quite frankly, you'll learn, and the evidence will show, there's something called touch DNA. What is that? You're going to learn that if I touch this table, and my hand is here for a couple seconds, I don't just leave my fingerprints behind, I actually leave some of my DNA behind. And that can be tested, forensically tested by the police and by the GBI lab and the state of Georgia. So there's no fingerprints on the guns that belong to DeMonte Kendrick. There's no DNA. There's not a single person at the party or a single witness who says DeMonte Kendrick had any of these guns. No one is going to say he bought any of the guns. No one's going to say he sold any of the guns. No one is going to say he possessed any of the guns. But they're going to want to do a dirty magic trick and show you his past. He pled guilty to a gun offense years ago. And so he must have been possessing the guns. That's their theory. Assume and speculate to find him guilty. That's not what we do in this country. That's not what we do in a democracy. That's not what we do with our Constitution. And that's not what we do when someone's presumed innocent and has to be proven guilty beyond a reasonable doubt. One witness, please, that says DeMonte Kendrick was holding a firearm that night. DeMonte Kendrick bought one of the guns. DeMonte Kendrick used one of the guns. No one. No one's going to testify to that. And why is that? Because he didn't have any of those guns. He was at a house where there were guns. That doesn't mean he was in possession of illegal firearms. You could go to a party where there are 50 people, somebody has guns, you don't know about it, maybe you do, but it doesn't mean you're possessing the guns. That's what the evidence is going to show. He was there. There could have been a bazooka in that house. I don't care. Mr. Kendrick, wasn't in possession of any firearms,
Bazooka.
illegal, machine gun, or otherwise. He didn't control a gun, he didn't use a gun, he didn't buy a gun, he didn't sell a gun, he didn't hold a gun. Not one witness. And there are dozens of people that they could call to say, oh yeah, I saw Mr. Kendrick hold a gun, but not one. And there could be hundreds of witnesses. I want to bury you with witnesses so that you'll forget about the presumption of innocence and what real evidence is required. Zero, not zilch, donut hole, reasonable doubt. What will they show you? What will the evidence show that night on March 9th? Well, they'll show that Mr. Kendrick was afraid. He's a black man in America, and there's a team of people swarming a house with firearms. He's not sure if they're police or not. But in 2022, after COVID, BLM riots, people like George Floyd died, he had a reasonable and healthy fear, fight or flight. Mr. Kendrick doesn't want to fight. He doesn't want to fight the police, and he doesn't want to fight people who aren't the police if they're armed. But he knew that there were people swarming the house with guns, and it turned out they were the police. So what did he do? He ran. He did the absolute smart thing to save his life. He was afraid, and he ran. And the police caught up with him shortly thereafter. Now, he's not charged with fleeing the house. He ran because he was afraid, and that's a reasonable thing to do for him. Given how he grew up, where he grew up, and the state we live. And when the police caught up with him, just shortly thereafter, did they find him holding an FN, the type of gun is what described? Did they find him holding a strap machine gun? Did they find him holding a Glock? Did they find him with an AK-47, an AR-15, or any other kind of gun? No! He was unarmed because he never had a gun. There's not a scintilla of evidence that you should believe that Mr. Kendrick is guilty of any of those 3 firearm charges. Not a scintilla. Hundreds of witnesses. I asked for one to come to court and say, Mr. Kendrick was holding a gun that night. What about the next set of charges? They're drug charges against my client. But all the drug charges against him, possession of cocaine, possession of codeine, all the drug charges alleged against Mr. Kendrick are again from March 9th of that year. From the date he was arrested, the party at Mr. Williams' house. And apparently the police find drugs in the house, where there are dozens and dozens of people. So again, I ask you, listen to the evidence. What will the evidence show? Will the evidence show my client's fingerprints on a bag of drugs? No. Will the evidence show my client's DNA on a bag of drugs? No. Will a witness come to court and tell you he was using drugs that night at the house? No. Is there videotape of my client snorting a line of cocaine? No. Is there going to be a witness who tells you that my client sold him drugs? No. Is there a witness that's going to tell you that my client bought drugs? No. Is there going to be any evidence that my client possessed, used, bought, sold, controlled drugs on the night in question? Absolutely not. There were drugs at the house, my client was at the house, there are dozens of people at the house. 1 + 1 does not equal 3. It's another Krispy Kreme donut hole for the prosecution. Zero, nada, zilch. You're not going to hear evidence that my client's blood or urine was tested and that in his bloodstream there was cocaine or other drugs. And The indictment says that the drugs that they're charging him with are from that date, March 9th, 2022, the day he was arrested, not any other day in his life. So the question you have to ask, the evidence you have to look at is he possessing drugs while he's at the party at that house? And there is no evidence of that, just like the guns. The next charge against my client is gaming activity. And the gaming activity they allege, very specifically in the indictment, it's not just any gang activity, it's gang activity related to the possession with the intent to distribute illegal drugs from March 9th of 2022. And again, where is the evidence? Not one witness. They also allege that he committed gang activity based on the guns. Same thing. There's just no evidence of it. It is not illegal to be part of a group in America. Freedom of association. Otherwise, the Atlanta Falcons would be an illegal street game because they wear red and black and they have certain symbols they wear. And the Braves, certainly the Braves, because they lost in the playoffs. Maybe the state of Wyoming would die dead. It's not illegal for my client to want to wear the color green and do fancy symbols with his hands. But they're going to bring dozens of witnesses in to talk about that. So what? That's not a crime. Illegal gang activity requires my client to have committed a crime and be in a gang. And YSL is not a gang, but we'll get to that in a minute. They want to attack free speech and freedom of association. They're guaranteed to us in the Constitution. And if they want to do that, then they should go out and arrest the Falcons and the Braves too. Not one witness is going to come to court and say, Mr. Kendrick possessed, sold, bought, used drugs as part of gang activity. Or possessed, sold, used a firearm as part of gang activity. I want you to tally, keep counts, take notes. How many witnesses the state brings in this case? Hundreds. And I want you to remember this conversation I'm having, this one-sided conversation I'm having with you all, about how many witnesses say, my client possessed a firearm because he was a YSL gang member. My client possessed drugs because he was a YSL gang member. What is YSL? It's a successful, massively, worldwide, internationally successful record label. And my client was a part of that record label and a successful rapper and blessed with the ability to make that music. And last I checked, those lyrics, which the state is going to try and use, are just part of free speech. So we've eliminated murder, we've eliminated the gun charges, we've eliminated the drug charges, we've eliminated gang activity based on gun or drug charges. So what's left? What's left is count one, RICO. Ms. Love told you, that's a term that most normal people don't use, for good reason. It's a very complicated legal term. Most lawyers don't even understand it. I'm going to try to explain it to you. And you've heard a lot about overt acts versus predicate acts. Are you confused already? You should be. They want you to believe, and they want the evidence to show, that Mr. Kendrick is guilty of this vast conspiracy because who his friends are, who he hangs out with, the colors he wears, on his clothing and the lyrics that he writes, the rap music that he makes. And they suggest to you this is all part of a vast conspiracy. But the reality is, some of these lyrics may be offensive to you, and that's okay. Because in a free society, we have free speech. That doesn't make it a crime. The state says that the evidence will show that they dug to find out the murder and then used the lyrics to support it. You know, I watched Goodfellas. It was a movie about real crimes that took place. It was written by Martin Scorsese and acted out by Robert De Niro. The DA's office is going to go arrest Mr. Scorsese and Mr. De Niro. They're exercising their free speech to tell a story. Why can't my client, Mr. Williams, do the same and write lyrics about crime? Maybe they're offensive. Maybe the movie Goodfellas is offensive because you see people committing crimes. But in a free society, we're allowed to exercise free speech. It's the price we pay to live in a free country, and it's a great price. Just because someone raps about murder or other crime does not make it a crime. Why do they rap about that stuff? Because it sells records and it allows them to creatively express their feelings about how they grew up and where they grew up. And they are proposing a war on the First Amendment of freedom of association and free speech. They don't like those lyrics. They want to send a message to all those inner city kids in Atlanta who dream about getting out of the ghetto and becoming successful musicians. And their message is, if you rap lyrics about crime, we're gonna indict you and charge you and brand you a criminal. That's un-American. That's wrong. The evidence will show that the state of Georgia and the city of Atlanta have been blessed in the last 20 years by the entertainment industry. And not just rap music, TV and film, and all kinds of entertainment. And some of it's fictional. And that's okay. It's okay to rap about crime or life or your experiences, even if it's not true, even if it didn't really happen. That's just free speech, ladies and gentlemen. That's not evidence of a crime. That's protected in our Constitution. It's a protected part of living in a free society. YSL was a very successful record label, and there's going to be evidence of that. It made millions and millions of dollars. That's not a criminal street gang. But it's not just a successful record label. It gave my client the opportunity to give back, to volunteer his time and some of his money. He coached an inner city youth football team. Does coaching that inner city youth football team support their RICO accusation? Because they told you the overt acts don't have to be a crime. Maybe now we should criminalize civic volunteer work. I don't know where it ends if we start making free speech illegal. They want to lump Mr. Kendrick in. They want to have you find him guilty because of other people's crimes or crimes that he already paid his debt to society for. So the state presented you some of the examples of that. Lil Wayne's tour bus got shot up. That's horrible. Whoever did that should be punished. But there's no evidence my client was there to pardon it. They're alleging that's part of this case. The shooting of Chanel Drinks you heard about, gunned down in a rental car. But they're not alleging Mr. Kendrick took part in that either. And what about the attempted stabbing of Rayshawn Bennett, Wyatt, who's known as Wyatt Benucci, another rapper, and the armed robberies they allege? None of those incidents involve Mr. Kendrick. But what they're going to argue to you is that if Mr. Kendrick was part of the YSL label, or what they call the YSL gang, then even if he's not charged with those crimes or involved in those crimes in any way, he should be found guilty of RICO conspiracy, even if he didn't commit a crime. And that's wrong. It's just wrong. That's why they have to go to such great lengths and bring hundreds of witnesses in to establish other crimes, other acts, other incidents that my client had nothing to do with. It's a bad magic trick. Look over here at Lil Wayne's tour bus. If they actually had evidence of my client committing a crime, we'd be here for a week, not months. The conspiracy they want you to criminalize is being a rapper in America and being successful. They want to attack the First Amendment. They want to attack free speech. They want to attack capitalism because they don't like rappers who rap about criminal behavior in Atlanta. And they're telling you that this is a pattern of activity, a trend to attempt to control and exert influence. But really what they're showing you is, if we don't like your speech, then some free speech is wrong and illegal. And you should find my client guilty as a result. They don't want you to find Mr. Kendrick guilty based on his actual actions, just based on the words he wrote and sang. They don't want you to find Mr. Kendrick guilty of his actual actions because they don't have the evidence of it. They don't have the evidence of a murder or illegal guns or illegal drugs. They don't actually have that. So instead, they've got to play their bad magic trick. But you're smart and you can listen to the evidence and you will see it's nothing but a Krispy Kreme donut. That's what the evidence will show. You heard about wiretaps. It's basically the police listening in on people's phone conversations. And that's fine. They get a judge to approve it, they're allowed to do that. And there's hundreds and hundreds of hours of wiretaps. And I dare you to listen to all that over the next few months and hear one time my client saying, I have a gun, I have some drugs, I committed a murder. It doesn't exist. Nowhere. I'm part of the YSL gang. Remember, they told you that the YSL is this sophisticated gang, so there's no written agreement, there's no verbal agreement. It's just something you have to trust them with. Does that sound right? Just trust that. Take the government's word. And they're going to bring in experts on gang activity to tell you that the record label is a gang because they think so. Well, they work for the state, for the police. They're going to tell you what they want you to hear. But use your brain. Use your common sense. All those wiretaps, you're not going to hear Mr. Kendrick say one time, I'm going to do something illegal. Whether it's a violent crime, a gun crime, a drug crime, or admitting he's part of a gang. Not once. In hundreds and hundreds and hundreds of hours of wiretaps. And why is it you won't hear that? Because what is he actually? He's a former convicted felon, a former gang member, and a current recording artist, a current rapper with YSL, any current member of society doing civic duty. They have to point at his past and get you to only look at that, because the actual evidence from March 9th and from January 10th, the 2 dates in the indictment that accused my client, there's no evidence of him committing a crime. The state turned over to us, the prosecution, 6 terabytes of data in this case. Now, I'm not a computer expert, but I want to talk to you about what the evidence will show. A lot of that evidence you're going to hear and see. What is a terabyte? It's an enormous amount of computer data. And here's what I'll sort of tell you the analogy is. If it were pieces of paper, 6 terabytes would be 420 million pages of documents. 420 million pages. That's how much evidence there is in this case. Is there one page? Is there one witness? One set of fingerprints, one set of DNA, one videotape that shows my client committed a murder, that shows my client possessed illegal drugs, that shows my client possessed a firearm, that shows my client committed illegal gang activity, or that my client conspired with others to commit crimes? It's a donut hole. It's a Krispy Kreme donut hole. You don't get the glaze, you don't get the donut, you just get the air in the middle. What did Mr. Kendrick do? Oh, they have pictures of him flashing gang signs and wearing green. They have pictures of him standing on the hood of Rayshawn Bennett's car at Lenox Mall. Oh, God forbid. He stood on the hood of another rapper's car, and they want you to believe that is the evidence that he's part of this vast conspiracy. No, standing on someone else's car, it's a nice car, is juvenile. It's silly. Maybe it's even a misdemeanor. But they didn't charge him with that misdemeanor. Instead, they charged him with a RICO conspiracy. Standing on the hood of this other rapper's car must be proof that he's part of this vast conspiracy they're alleging. Quite frankly, the real juvenile behavior is all these hundreds and hundreds of witnesses to try and prove something that doesn't exist. There are lots of other overt acts, and I'm not going to belabor each one of them to you because you heard most of them from Mr. Steele and from the state. But you've also heard from me. If there's a witness who says Mr. Kendrick possessed a firearm or possessed illegal drugs or murdered Donovan Thomas, they saw him murder Donovan Thomas, then bring that person to court. Mr. Copeland, their star witness, is going to come to court and say that Mr. Kendrick admitted to him, Mr. Copeland, that he was part of the group that killed Donovan Thomas. You going to believe Mr. Copeland, who has every incentive to lie? That's the evidence they want to rely on? That's what they're keeping us here for months and months for? The guy who was charged with the crime, who now says it's not him, it's my client instead? Please tell me there's something better, something else that we're here for. Please tell me we have anything near proof beyond a reasonable doubt. We don't. There's no real or concrete evidence my client committed a crime. Not a single offense. Not RICO, not gang activity, not guns, not drugs, and definitely not murder. Ms. Love talked about the wolf pack. I understand that. She thinks the evidence will show that. But I really think it's more like the boy who cried wolf. You know that old story. There's a wolf, there's a wolf, there's a wolf. And it turns out there wasn't a wolf. That's the state's case, ladies and gentlemen. And that is why you will come back many months from now and find my client, Mr. Diamante Kendrick, not guilty on every single count. Thank you.
Would he like snatch himself away from the stand here? All right, so I have one more thing queued up for you guys. We are going to watch JApp do Cross of Underwood. So let me switch over to that tab. I think I have it queued up to the right spot, but we'll see. There are no captions available for this clip, so sorry, we won't have captions for this. This is fast forward from day 2, which we just watched, to day 148 with opening statements. So we're going to get that Cross of Kimberly Underwood, a little more JApp before we wrap it up for the day here. If you're just getting in here, court is adjourned. No court tomorrow. They're adjourned until Monday at 8:30 in the morning. Opening statements should start on Monday, and the state goes first. So we have 5 hours of the state delivering closings. And then some defense. We'll probably hear some defense close Monday. Tuesday's a short day, but Whitaker wants to finish up closing statements, and jury can start deliberating Wednesday is the game plan. So we'll see if that holds up. Thank you again to Chloe Albert's Revenge. Talking about Yak fleeing with the raid. He did not flee. It was aggressive traveling is great. Like, this was so great. And also this thing, you heard that we only watched Max Shart and JApp do opening statements, but both of them gave some attention to Kenneth Copeland, right? And Chloe lays it out here. This is like in the voice of the state. Well, he's a liar, but he said that he lied, so we don't believe him. Like, the pick and choose of when the state wants to say he's reliable. We know you didn't do the murder. We won't prosecute you unless you go up there and tell a bold whopper of a lie. A bold-faced whopper. So just think about that. Like, for 2-3 years, the defense attorneys have known that Kenneth Copeland was going to be a mess. And the state just still thought they'd be okay presenting it the way they did. So, thank you so much again, Chloe. Harp City says, ain't no crime to be slime. Right? Abate slime flash tie. Yeah, today he had that bright green tie. Abate self-awareness called you out. I think he probably was aware when he chose it. I can just picture him wanting to, like, oh, see if the internet says that my tie is slime green. So I don't know. Thank you so much, Harp City. And then Brad here with the hot take says, this dude is trash. Old boy is going to prison. This is a bad showing. So I think that everything he said, and again, we are on day 165 with both parties resting their, we're into closing. I think his statement, his opening statement, bullet points what I've seen throughout the trial. And the judge confirmed some of what he said by issuing a directed verdict for several counts for Diamante Kendrick. So I don't really know if this, maybe you're saying it's trash because of you just don't like his delivery style, but as far as the substance of his opening statement, the arguments he made about the same charges that Judge Whitaker gave an acquittal on through a directed verdict yesterday, I mean, can't say that that's a bad showing. And those charges are now gone, and he cannot be retried on those charges. So I respect it. I would love some clarity here if you mean that he's trash because of the delivery or because of the argument he made, because the argument he made here was just confirmed, upheld by the judge, agreed with by the judge in her ruling yesterday for those counts. So, but still, I think it's important to see what someone might think of someone's presentation, because anybody can be on a jury. So, and then I think this cross here with Underwood, I think they took a pause for a minute. I think they took a pause. Let me change this banner to say we're not doing opening statements, but JApp. That way our banner's not wrong, because I do that a lot. Definitely do that a lot. I think we're queued right up, so.
Thank you, Your Honor. Good afternoon, Detective. My name's JApp. I represent Mr. Kendrick.
How you doing?
I'm well. How are you?
Good.
So I listened carefully to your testimony. When you were giving an answer about, or answers about a photograph depicting Mr. Kendrick standing on the hood of a vehicle, you said you wanted to focus on, quote, the crime at hand and who committed it, correct?
I didn't say it was a crime. I said it was disrespect.
Okay, so you don't believe that my client was committing a crime?
If he didn't damage the vehicle, no.
Uh-huh. All right, great. And you didn't, you perceived that that was an act of disrespect, correct?
Yeah.
Okay. Did you question Mr. Kendrick or any of Mr. Kendrick's associates about him doing that?
I did not.
Did you question Mr. Rayshawn Bennett about that incident?
No, I didn't.
And to be clear for the jury, Rayshawn Bennett is the person who you believe owned that car, correct?
Correct.
He's also known as YFN Lucci, right?
Yes.
So you didn't question him about how he perceived it?
No.
And you didn't question any of Mr. Bennett's associates or friends about that incident?
I didn't, but Mr. Lucci spoke out on a pod with how he felt about that.
Okay. But you don't know for you're assuming that it was gang related, correct?
I'm not assuming. I know what was going on when that happened.
You didn't question anyone involved, but you knew
I didn't
what was
have to
going on?
question. I knew that it was a gang beef going between YFN, Lucci and his crew, and also YSL and their crew.
When is the last time before that photograph that Mr. Bennett and Mr. Kendrick spoke in person? Do you know?
I think they ran into each other at Lennox, but that was just according to social media. Or they actually talked about them running into each other or talking.
Do you know whether or not they ran into each other that day at the mall?
I think I saw something on social media saying that they did.
Is it possible that they made a bet that day and this was just someone winning a bet?
I don't know what was said.
You don't know, right? Because you didn't ask anyone, correct?
No, but the guy stood on the guy.
Let her finish her answer, and y'all are kind of talking over each other, so try not to do that. Thank you.
Sorry, Your Honor.
It's all right.
I don't know it, but I don't think they even made a bet because, like I said, it was a lot of animosity and tension between the two groups.
And you wouldn't know because you didn't bother to question any of them, right?
I didn't question them, no.
Yeah. So you don't know for certain whether it was gang related or a bet or what the reason was or the intent was behind Mr. Kendrick standing on that vehicle. That's fair to say you don't know because you didn't question any of them.
I saw the reaction of Mr. Lucci when he was questioned about it.
Why not ask him? Why not go and ask him then?
I didn't have to ask him. I saw his reaction. He wasn't happy.
You didn't have to follow the evidence?
He wasn't happy.
It's possible he wasn't happy because he lost a bet and had nothing to do with gang activity?
Objection, assuming facts, not an evidence about
Yeah,
the
it
fact.
is assuming facts. You don't know one way or another what the reason or intent was in my client's mind. Isn't that fair to say?
I don't know what his intent was, but he got a reaction out of Lucci.
You believe in the First Amendment, right?
I do.
You believe in people's right to free speech?
I do.
You believe in musicians' ability to create lyrics for art, right?
I do.
But you stated in your testimony that you think rap music that depicts violence is popular, but it shouldn't be.
I agree. It shouldn't be glorified.
And
I stand by that.
You also said that there are songs which have killed children in Atlanta. Which songs?
I don't know specific songs, but I know that it's music. The reason for the beef, as far as the Atlantic Station situation, they were going back and forth on social media with songs and disrespecting each other. Next thing you know is gunplay and children are dead.
You're the expert, detective. Which songs? Which songs regarding rap violence caused the death of children?
I don't know the name of the songs, but I know that those particular kids were involved in music, talking about each other in the music. Then it's violence spawned because of the music.
Do you think you should be an expert on rap lyrics?
Sustained.
I never said I was an expert on rap music. You said that.
You understand that lyrics and even lyrics about violence can be used as art to depict, to be marketed and for commercial purposes without being factual, right? You agree with that?
I have heard of that and seen that, but
and that can be done in
it's
movies.
it's not a good thing. That's all I said.
Not a good thing?
Right.
You ever seen the movie The Untouchables with Robert De Niro?
Probably not.
No? No. Goodfellas?
Seen Goodfellas.
Okay. So do you think Robert De Niro should be charged with crimes because he depicts murder and violence?
No.
What
He
about
didn't
Al
do it.
Pacino?
If he was charged when he stepped off the movie set and he went and did the actual things that he did in the movie, then yes, he should be charged.
But you said in earlier testimony that if it's depicting previous actual acts of violence, then that should be a crime.
Like I said, if Robert De Niro left the movie set and went out and shot somebody like he did in the movie, then yes, he should be charged.
That's not what you said earlier. You said,
I would say argumentative, Your Honor.
okay. Did you say earlier that someone who is rapping about a previous act of violence should be held responsible for that?
That's not what I said.
Okay.
I said that they put in the music or in the wording of the songs things that have happened, meaning whether it was a shooting, whether it was a drive-by, whether it was a smash and grab, whatever. I say that sometimes this can be a confession, sometimes it can be taunting just to the other gang members or the ops or whatever.
So if it's taunting, then it should be criminalized. Is that your?
I didn't say that either.
Okay. So Bob Marley singing "I Shot the Sheriff" is okay too, right?
You shoot the sheriff in real life like that man did up in Kentucky, then yes.
Yep. Yeah.
Or if it's like the sheriff shot the judge.
You don't know much about Bob Marley's life, do you?
What do I got to do with anything?
You understand that you've already testified that you have no concrete evidence that the lyrics that were played in this courtroom earlier are directly related to any actual criminal activity, right?
I didn't say it was connected to criminal activity. I never said that.
Well, okay. So they're just art. They're just free speech then. We can agree on that?
It's free speech, but like I said, when you talk about a crime that actually happened and your group is the suspect, it's
what? It's what?
It's obvious that you were involved maybe in that crime.
It's obvious that you were involved if you're singing about it?
Could have been.
Yes, sir.
I'm going to object to the characterization of it's obvious that you were involved maybe. And I'm going to object to Mr.
Overruled. What else? Hang on. To Mr. App's misstatement? Is that what you said? Ask your question again.
Thank you, Your Honor. So what you're saying is if someone sings about an act of violence that previously occurred, then it's obvious that they were involved.
That is a misstatement. That wasn't.
Is that what you're saying?
Not exactly. I'm saying that if crimes have been committed and then you go brag about it in a song, it's hard to defend that you didn't have anything to do with what you're pretty much confessing in a song.
Okay, and I guess that's my point. If Robert De Niro plays Al Capone and he's playing Al Capone in a movie, is it then obvious that he's the one who's in the mafia? I don't understand. Why is it that singing about a previous crime that occurred somehow ties you to that crime? What evidence do you, and let me rephrase, what evidence do you have that either Mr. Kendrick or Mr. Williams actually committed the murder of Donovan Thomas?
I didn't tell you that I had evidence of that. Did I tell you that?
You testified.
I testified that they killed Donovan Thomas?
You testified that it was obvious.
Got me
a moment
mixed
ago.
up. I didn't tell you that.
So it's not obvious that they're involved?
Objection, Your Honor, because I'm not sure where we're going to go, and so I want to.
Well, a minute ago.
Hang on and let me listen to her objection.
Can we approach her?
Yes.
They do this approach.
All right, Detective, we just want to make sure that with regard to Mr. App's questioning, he's going to confine his questions to things that have to do with his client, Mr. Kendrick. And you should likewise confine your answers to things that have to do with his client right now while he's the one questioning, okay? And not talk about any of the other co-defendants on trial here. And things like a search warrant that got the results of which were suppressed, don't even veer into territory like that. And I'm not going to go through all of the different possibilities, but just be mindful when you testify to be careful not to testify to anything that, as an experienced detective shouldn't be being talked about, okay?
Okay.
All right, any other kind of parameter anybody wants to mention?
Well, Your Honor, and I guess I'm speaking to the detective as well. Detective. I represent Shannon Stillwell. I am not asking this question, and he is specifically asking about Mr. Kendrick. I would not anticipate that the answer would include pronouns such as they or things of that nature. And I would ask that anything be strictly limited to Mr. Kendrick.
I understand.
All right, anybody else?
I'll absolutely limit my questions relating only to Mr. Kendrick.
All right. Okay, I think we're ready to get the jury back. They may not be ready to come back, but.
Detective, you were saying that and I don't want to misquote you, but that if someone raps or sings about an act of violence that actually occurred, then it becomes obvious of what?
To me, it's bragging. Could be taunting or bragging.
And well, let me ask you this. Are you aware of whether Mr. Kendrick wrote any of those lyrics that were played in the courtroom earlier?
No, I'm not aware.
So you don't know if my client was even involved in writing those lyrics.
I never said he did.
And you're not aware of Mr. Kendrick in any way, shape, or form being tied to or involved in the murder of Donovan Thomas. Isn't that true?
I know he was arrested and charged or a suspect for it.
Were his fingerprints found anywhere?
I didn't work the homicide portion of that. You would have to refer to.
You don't know if his fingerprints.
I didn't get into the homicide investigation.
You don't know if his fingerprints were found on the Tahoe or any evidence in the case?
No.
You don't know if his DNA was found?
No.
You don't know if any ballistics were found that were tied to Mr. Kendrick, correct?
No.
In fact, you're not aware of any eyewitnesses who saw Mr. Kendrick commit that crime, correct?
I don't know of any.
And you went to great lengths to give an expert opinion about what the state refers to as exhibit, I believe, exhibit 535YB, which is the song called Slime. And I apologize, I may be less genteel than Mr. Steele is, but it's a piece of evidence. The song's actual name is Slime Shit. Is that right?
That's correct.
Okay. And you stated earlier, you don't know the date that song was released, right?
No, I only see the date that it was uploaded to YouTube, like I told Mr. Steele.
You don't know the date it was written?
I don't.
You don't know who wrote the lyrics?
I don't.
And so if that song, if I told you that track was released officially on September 16th of 2015, and that
Objection, assume effects not evidence.
Sustained.
I'll withdraw the question. If hypothetically, if those lyrics were released in 2014, before the murder of Donovan Thomas, then wouldn't it be fair to say that the Tahoe mentioned in the song had nothing to do with Mr. Thomas's murder, right?
That would be fair.
You're not suggesting that whoever wrote the lyrics was psychic and predicted the murder of Donovan Thomas, right?
I did not say that.
Okay. Thank you. I have no other questions.
All right, are there other defense?
So there you go. We got a, after doing the opening statement rewind, we got a little look back there at some moments from Jay Apt in this trial. It's not unusual, you guys. Doug is, like, he's lead counsel, essentially. Jay Apt has been here for several stand-ins. We've also seen Katie Hingerty. I don't remember, there was another guy that stood in before as well. Don't remember his name. So sorry, can't recall his name. But not unusual. But it seems like, and thanks to the chat says that Doug recently said in an interview that he, meaning Doug, will be doing closing statements. So, but I think it's really interesting to watch that in retrospect and see, like, their outline, their framing of what we're going to show you in this case and what the state's not going to show, what they're going to show you instead of what they should be showing you, has panned out the way it's panned out. So that's what I've got for today. If you're joining late, remember there is no court tomorrow. There's no court tomorrow. We'll be back at 8:30 a.m. on Monday. Closing statements are expected to start on Monday, half day Tuesday, and if all things go well, deliberations can start on Wednesday, right before Thanksgiving in America. So Thursday will be Thanksgiving. And that, I think, could have some impact on jury deliberations, depending on if they have enough time to get through everything. 8 hours might be a quick turnaround, but it can be done. So, as far as I'm pulling up YouTube, this is an odd time of day. I know Survivor Speaks is going to be live at 6 p.m. as well as Excited Utterance. And then Flesh of the Gods tonight at 8 p.m. But this is a weird time. I don't know who's live right now. We can take a trip over and see somebody. I was thinking, is Empress Fox still on? I didn't see her pop up. Yeah, so Empress Fox isn't still on because that's where I was thinking, but I don't see her coming up. Taylor Umbridge is live. I wonder if she's looking at the seizures. Because it's called Where's the Money At? So let's see. We could go over there. Not exactly sure. We'll do a redirect over there, but she's been doing a lot of coverage on YSL and Fulton County stuff, so. And familiar name, I think she was doing a lot more content over on TikTok before she started doing YouTube, so. So we'll do that. And then, I don't know, like, if we do something tomorrow, I said do. If we do something tomorrow, it'll be a rewind maybe if we talk about YSL. If not, probably catch you in somebody else's stream in the chat. So, let's see. All right, so I've saved the redirect here. It'll go over to Taylor's channel. I have it up and I see some familiar names in the chat, so I think you guys will have a good time over there. If not, pop over, say hello, hit that like button. And I'll link to it as well, Taylor Umbridge. There you go. And I think that's it. Yep, we've got Flesh to the Guide. I said 8 p.m. tonight, as well as 6 p.m. Survivor Speaks and Excited Utterance. So I'll be around, especially since I have a little bit of free time. I will be around in these chats later. Other than that, we got to end this poll. I forgot we had a poll. So we are thinking, what do we have here? With 1.8 thousand votes, and it's 4 options here. So 59% say not guilty, 19% say split, 17% say hung, and 4% say guilty. So that's I think, obviously I think this chat might lean a certain way, but I think it's very interesting to still see that there's a 59 for not guilty, but 19 for split. That we will get a verdict, but it'll be not all the way not guilty, not all the way guilty. So thank you guys for giving your feedback there. Always good to see what people are thinking. And see you over at Taylor's channel, you guys. You guys all have a good morning, evening, good night, and see you maybe tomorrow, maybe Monday. I don't know yet, but thank you so much.